take our first case, United States versus Rooney. Ms. Albro.
Thank you, Your Honor. Good morning. May it please the court. I'm Kimberly Albro here on behalf of the appellant Danny Rooney. There is no doubt that the courts construe statutory language strictly. The issue here should be fairly easy to resolve when the plain language of 4243 is applied. 4243 G and F.
But most circuits disagree with you, don't they?
That is correct, Your Honor.
And they're all wrong.
I'll be happy to distinguish those cases. I would start with, I would say that that Franklin out of the Eighth Circuit made it very clear that it's hard, what they said exactly is that it's hard to conclude that imposition of the supervised release conditions that were imposed in that case were part of the treatment regimen per se. So even they recognize that the statute itself does not authorize these type of supervised release conditions in the context of 4243 and 4246.
When somebody is put into the institution on the front end, right? So this is the back end, but on the front end, we tend to think that like that institutionalization is part of the treatment. Isn't that right? I mean, that's what we're doing. We institutionalize them as part of the treatment.
Once they're found not guilty,
Yeah, right.
right, they are, if they cannot show that they are not a danger and need continued treatment, they're turned over to the Attorney General. So then they are institutionalized to be evaluated by appropriate medical staff.
Evaluated and treated, right? The point
Correct.
being is that one of the questions that we're trying to answer here, it seems to me, is what is included within this type of medical or psychiatric treatment, right? And I think we know, based on the broader scope of what's happening here, that something like institutionalization is part of the treatment, right? That type of restraint on liberty is a part of the treatment, right? And so the question I've got, and we've seen some other sort of courts that have sort of done this, where they've said like group homes, like placing someone in a group home is part of treatment, right? And so the question I'm getting at, I take your point that it needs to be part of the medical treatment, but why aren't restrictions on liberty that might not involve pharmaceuticals or colloquially lying down on a couch and talking to someone, right? Why aren't those types of liberty restrictions also part of medical treatment?
Well, the terms used are prescribed regimen of medical, psychiatric, and psychological care or treatment.
But we know that
terms are-
includes restraints on liberty that are not directly treating the mental illness, right? So like, they're related to the treatment, right? But they are not the like administering of the medicines themselves, right? So we don't interpret medical treatment in, I think, the way you want us to read it, which is if it doesn't involve pills or a couch. I know I'm being a little colloquial in that sense, but if it doesn't involve either pills or a couch, it's not treatment. And I don't think we think about it that way in this system, where we think about medical psychiatric treatment to include both the pills and the couch, but also restraints on liberty. Why shouldn't I interpret the language to include restraints on liberty that are related to the mental challenges that exist?
Well, I would agree that there are certain restraints on liberty that fall within the treatment regimen. For instance, when you said group homes, Mr. Rooney one of his conditions was that he attend, I think it was Columbia Mental Health. He was to live in a kind of in-house facility, kind of a group home type place. And I do think those were specifically geared toward his medical treatment. I mean, a regimen means a systematic.
But a big part of the reason that we put somebody in an institution or in a group home is out of the fear that they're going to harm themselves or others, right? It's a liberty restraint on them. And so it sort of feels like to me that like a lesser liberty restraint, that is, that you can't have guns, is also part of that same type of treatment, where we're trying to make sure that they don't hurt themselves or others, in the context of like also trying to manage their medicines and also trying to manage their other types of like purely medical treatments.
Well, I think you go back to Congress and how they wrote the statute, and all the terms are geared toward more the medical side, the treatment side, the regimen.
I understand, but you've agreed it includes restraints on liberty, right? Like institutionalization and the like, right? So I get, you could make the argument, like, treatment does not include restraints on liberty. I understand that argument, right? But you don't seem to want to take, if you want to make that argument, I understand. I think it's wrong, but you can make it. But once you accept that it includes restraints on liberty, then why aren't we just talking about what's related to the treatment? So we might not say, like, having to pay a fine, for example, like, that's not part of treatment in any sense of the word. But like, this kind of restraint on liberty is.
Well, the possession of a gun, in no way, I mean, I don't think under any definition you could say that's part of his treatment. It's not something that is a systematic plan of some kind of treatment to help his health get better, which is what regimen means. So.
I want to be sure you answer all of Judge Richardson's questions, but to me, I think there's a kind of a condition precedent to that, which I think all of the circuits except the one that agrees with you have embraced, which is the term in the statute that says explicit condition of release necessarily implies there are other conditions that would not necessarily be part of the prescribed regimen. I understand you disagree with that, but I can't think of any universe in which you could explain to someone that a mentally disturbed person who has either avoided prosecution or been committed in lieu of should be permitted to have a gun. Can you?
Well, 922G4 prohibits someone who's been deemed a mental incompetent from having a gun. The point is this statute is geared toward treatment of the mentally ill. It is not, nor was it ever intended to comprehensively cover every potential dangerous situation that someone.
It seems like they would have written that section differently if that was the intention, because I can't conceive of any situation where part of the prescribed treatment would include for a mentally deficient person having a firearm.
But I think this is geared not toward supervised release type conditions, which I think is often confused by the courts, because back in 1974, the Supreme Court issued their Jackson versus Indiana case. It made a very great distinction between someone who has been adjudicated, had their due process rights in front of a jury on a criminal charge, versus trying to handle someone who is different because they're mentally incompetent and might need a different kind of treatment. And I think that dangerousness alone is not the only consideration for revocation of conditional release. And I would say, I specifically wanted to address the point that you brought up when it says an explicit term of this release. But the subsection above that, 4243F2A, outlines other conditions, I would say. It actually says it's a treatment regimen. Here, you have to impose this treatment regimen, and as an explicit condition, tell them to comply with this treatment regimen. So every individual will have a different kind of treatment, a different kind of mental illness. They would have to have different conditions imposed, so it wouldn't be possible for Congress to outline those conditions in the statute. But just because it refers back to an explicit condition of release that they must comply with it doesn't mean that there aren't other conditions in place. For example, Mr. Rooney was told
The answer to the very first question I asked you then would be, all these other circuits are wrong, because I think they've all embraced this concept of explicit condition does not bar and implies there can be related conditions that are part of that regimen,
Well,
which is okay. I mean, you can be part of a lopsided minority in a circuit split. You may be right.
I mean, the 11th Circuit, I mean, obviously, Mr. Rooney believes that CRAPE applies and that CRAPE has the right analysis, agrees with the 11th Circuit. And as I said earlier, Franklin points out that they agreed, the 8th Circuit, that the treatment regimen is not per se within the statute. Jane talks about all of these non-treatment conditions, but Jane and almost all, as related to almost all the conditions that weren't strictly medical, referred to another statute. They referred to other statutes that would authorize these type of conditions. In CRAPE, the government urged the 11th Circuit not to view 4243, quote unquote, so literally. And in this case, the government urged the district court below to not to take a restrictive view of the statute. And I think all of those terms and all of those holdings show that the courts are stepping outside of what the strict.
Can I ask you about the timing of the challenge? In the supervised release context, we say if you want to challenge a condition, you must challenge it when it's entered. You must bring the appeal and challenge that condition then. And if you wait to the revocation hearing to say that the condition that imposed was improper, as opposed to the condition imposed was not met for some reason, that collateral attack on the prior conviction, we lack authority to consider that collateral attack. Is there any reason for us to think that that same timing mechanism doesn't apply here? So your client had conditions imposed, had the opportunity to appeal that decision, chose not to do so, and might have had good reason not to, because perhaps without this gun condition, the district court may not have released your client. You may well have come out differently on the balance of whether they were continued to be a risk or not. And so your client might have had very good reason not to appeal that gun condition at that point. But the district court made the balance at that point, including this condition, where now time has gone by and he wants to bring this collateral attack. We don't allow that in any other context that I've seen, supervised release or otherwise. Why should we permit a collateral attack in this kind of a context?
Well, I think because to reach the issue about whether his revocation is appropriate, which is an important due process right of his, just like the CRAPE court, they were faced with the same situation, and determined that
I understand, they have an argument that like, is that what you're relying? I understand that argument. I don't think it's a good one, but I understand it. The footnote where they talk about the different subsections. I understand that. Is that the argument that you have?
Well,
do you want to make any other argument, I guess? I just want to make sure I understand what you would say in response to that beyond, and you can just lean, I'm totally fine with you just saying, yeah, I just adopt the footnote. That's all I got. But is there anything else you want to say to it?
Well, I mean, we tried to focus on the actual revocation. And even if he didn't challenge the conditions when they were imposed, is that enough for him to now have his revocation, have his conditional release revoked because of this one factor?
But wouldn't that same argument work in the supervised release condition context? Because it says you can only revoke supervised release for a violation of a supervised release condition. And your argument is, well, this wasn't a supervised release condition because it was improperly imposed, right? So it's not a supervised release condition because of the nature of its imposition. Like, that's just a circular way. That seems like to me an entirely circular argument, right? Like, if it was imposed as a supervised release condition, then when it comes time to revoke, we revoke as a supervised release condition because that's what the court called it and that's what the court did. And that's all the court had the authority to do.
Right.
So the CRAPE argument in the footnote would just be flatly inconsistent with our supervised release cases.
Okay. Well, I would point out here, there were two other conditions listed in his petition. So I think that's faulty because two of the conditions that he allegedly violated were not conditions that were in the court's order. It was leaving the district without permission and committing a new crime. Those were not explicit conditions, and the court did reference those upon.
Has he challenged this? Is this an issue that's before us?
It's in the brief.
But have you alleged that's like an error that requires relief? I'm not sure I understand that.
Well, it is. I put the outline of all that in the briefing about the two conditions, and that the only one that could be at issue is the possession of the gun, because the other two were not conditions. That was part of his briefing when he asked the court to dismiss the petition, and all of that was included in briefing. And then in the order, the court at one point references, like at the end of the hearing on the revocation, the court references I'm sorry, I'm over time too, so if you want me to. Okay, at the end of the hearing, the court does reference all the conditions that were listed in the petition, even though Mr. Rooney had previously objected to those conditions.
All right, thank you very much. You've got some rebuttal time, Mr. Holliday.
Thank you. Good morning, and may it please the court. I'd like to start to try to capture a little bit on what Judge Richardson was talking about with restraints on liberty, but also, Judge Agee, what you were talking about in terms of sort of what the other circuits have decided in terms of Franklin, Jane, Phelps, but also I spent a good bit of time yesterday in Perkins as well. And Perkins was informative, obviously, coming out of this circuit about. It was a very deep dive into the history of mental health in this country and the origins of 4243 and sort of Chapter 313. And
That's Judge Volk's
it
100-pager?
is. It is. I learned a whole lot about mental health yesterday and sort of how we got to where we are here in the Comprehensive Crime Bill of 1984 and how this is the regime that was decided on. And as Judge Volk was reviewing all of the history of it, there's this balancing of interests that I think that comes into play. One is we have an individual who has been deprived of liberty, sort of in a gradual context. Initially, it was the deprivation of the ability to have a firearm, but obviously it extends all the way up to when we're talking 4243G, someone remains institutionalized. And why do we do that? Why do we have that whole process in place? One is because in certain circumstances, and in this circumstance, the defendant still poses a threat to the public.
Looking at subsection F, which is revocation of the discharge, which is the section that we're focused on here because
Right.
this arises in the context of revocation, specifically the listed failure to comply, lists repeatedly, failure to comply with the prescribed regimen of medical, psychiatric, or psychological care of treatment. The person may be arrested, et cetera, et cetera. The court shall, after a hearing, determine whether the person shall be remanded for his failure to comply with the prescribed regimen of medical, psychiatric, or psychological care or treatment. Nothing in this section that discusses conditional release references any conditions outside of failure to comply with the regimen. And so I'm specifically focused on the language of F, which seems to make no reference at all to any ancillary conditions that were placed on release, and seems to conflict with the construction of the Jane line of cases with regard to E2B. How do we square that?
Right. So when the Franklin Court, the Jane Court, and the Phelps Court were grappling with that, where the language is somewhat restricted and confining it to medical, psychological, or psychiatric, they turned to principles of supervision, such as that found in 3603(8), which just talks about generally how the probation office has a responsibility to supervise somebody for 4243.
But this isn't
within the-
supervised release. This is a completely different statute, and my understanding is that they were actually promulgated sort of as a package in 3583. I mean, there are different statutes, there are different schemes. One is about supervised release, and any conditions essentially can be placed on supervised release, but this statute specifically says only certain conditions can be placed, and it's really not about it's about the individual's mental health. And at a minimum, those cases say the conditions have to be reasonably related to the mental illness, and I assume to the initial crime, and the initial crime in this case had nothing to do with anything violent, use of guns. They were sending letters, threatening letters, as I understand it. Is that correct?
That's exactly correct. He was sending threatening letters to his attorney at the time. He was diagnosed with being delusional, and the manifestation of those delusions was often violent. These were very violent letters that he sent to his initial attorney.
And presumably, if he was released upon recommendation of the director of the facility, he was found no longer to have that mental health condition. And none of the allegations of violation of of these conditions had to do with his mental health.
Well,
The allegations had to do with possessing a weapon, which, to my mind, is not reasonably related to the original crime or his mental illness, and then these other conditions that were unenumerated.
I think what we get to there, though, is sort of this comprehensive idea of not only are we looking out for the interests of the individual,
And
Mr.
where does
Rooney.
that appear in the statute, that we're not just looking out for the interests of the individual? I understand that you read it generally into the statute, but where does it appear in the language?
Well, it's the balancing that you get in 4243G when you're talking about whether or not somebody still poses a danger to, physical danger to the safety of an individual or to substantial property damage or whatever. So, I think that with Mr. Rooney, you have somebody who suffers from delusions, has violent tendencies. These letters are threatening. And so in preventing
Right,
him.
but the court, after hearing to determine whether the person should be remanded to a suitable facility on the ground that, in light of his failure to comply with the prescribed regimen, medical, psychiatric, or psychological care or treatment, his continued release would create a substantial risk to property or another.
Right.
So you're just reading out of the statute the phrase, "in light of his failure to comply." Essentially, you're asking us just to strike that out and read the sentence without that condition.
Well, I go back to what's found in F2, and it says as an explicit condition, and where the drafters contemplated that there would be conditions outside of the medical, psychological, or psychiatric conditions. And it doesn't make sense, at least to me, that you would have as a conditions of relief imposed in F2, a condition imposed that, respectfully, I disagree.
F2B is a subsection of F2, and F2 says specifically, his conditional release under a prescribed regimen of medical, psychiatric, or psychological care or treatment. And then the subsection under 2 is 2B, which says, order as an explicit condition of release, referencing back, I think, to F2. So you're essentially reading that an explicit condition of release as a whole new section in the statute that is not nested within the other language of conditionality.
Well, I think it's illustrative language. It's clearly language that the other circuits have found persuasive in finding that.
All but the 11th.
All but the 11th, yes, clearly, all but the 11th. And even in this circuit, in the Perkins case, any conditions that were reasonably related to the underlying condition were viewed as legitimate ones. And I would say that also.
How is the possession of a gun reasonably related to the original condition?
Is reasonably related because the manifestation of Mr. Rooney's delusion, which was violence. He sent violent letters or
Did
threatening
he
letters.
commit any violence? Was he alleged to have been violent?
Yes, but you would have to go back to the original state conviction, the Abhan conviction, that led to the appointment of the attorney who was then subsequently threatened by Mr. Rooney.
Do you take the relation here, I actually don't know the answer to this, but do you take the relation here, is the relation to the offense that he was found not guilty by reason of insanity on? Or do they have to relate to his mental illness?
I think it would have to be broader, because, I mean.
So it's the mental illness in a whole So it doesn't really matter whether it relates to the letters or not, although we might think it does here. The real question is like, does it relate to the like reasonable treatment of this person? And this person encompasses all the things that have come before and that might come in the future, right?
Yes, and that's also where we ended up during the ultimate hearing in front of Judge Curry was, you know, when Dr. Lloyd was testifying, she talked comprehensively about sort of the treatment of Mr. Rooney. Obviously, the violation was based on conduct outside of his institutionalization, but during the
Do we
hearing.
have the transcript of the hearing where Judge Curry imposed these conditions?
We do not, it's not part of the record.
Where-
Only the orders.
Where's the reasonably relate to in the language of the statute?
Oh, it's not. It's
So
within
you're
the
just
language
again
of
asking us to read something that's not in the plain language of the statute that Congress passed, that it's reasonably related to something. And what's it
I'm asking-
reasonably related to, we have no idea.
Well, I'm asking you to take into consideration the way the court has interpreted the statute.
And the other circuits have also read in language to the statute that wasn't in the statute that was passed by Congress.
What
And the
they've-
reasonably related language is in the other statute that was passed in the same package, isn't that right?
I believe so, but,
So Congress knew to say reasonably related when it wanted to, but it didn't do it here.
well, Congress also knew when they drafted F2 that they put an explicit condition rather than,
As a subsection of E2, which says his conditional release under a prescribed regimen, and then refers back to those explicit conditions.
In the other statute that Judge Berner's asking about, when it uses this term reasonably related, what is the relation there? What are the two things that are related in that statute?
I'm not sure, I'm sorry.
I wasn't either, that's why I was asking you.
No, but I think when the other courts have, you know, developed sort of a holistic way of looking at the statute, one that makes sense, not, you know, ultimately, we're trying to set up Mr. Rooney and similarly situated individuals for success. And the conditions that are placed on him, the 12 conditions in 2016, the 10 that were in 2014, are in place to try to get him treated and also to avoid any further harm to the public such that he can remain without any further restrictions on his liberty. You know, so as Judge Agee said a moment ago, you know, under what circumstance would you have somebody who's delusional and has written threatening letters, has a state conviction for Abhan? You know, when he violates in 2016, he goes into a Dollar General and shoots the place up with a gun. Why would you not have a condition in place to
And
prevent
he was
him?
charged, convicted, and served time for that offense,
He did. He did. He was,
and not found to be delusional, nor did he plead guilty.
he did not. It's interesting if you read how they got there. It was an iterative process, and they were able to get him to the point of competency such that he could plead guilty.
And he wasn't found to be mentally incompetent after that. He was simply found to have violated a condition that was placed on his release long before. But the subsequent crime that was using a gun and shooting up the dollar store, he was never found to be incompetent in those proceedings.
He was ultimately found to be competent after an iterative process of getting him there. You know, mental health is challenging. At the point of his evaluation by Dr. Lloyd, he was the Dollar General crime occurred in 2016. His release is coming up in 2024. There was an evaluation of Mr. Rooney in 2024 to see where he was then. So clearly before 2016, he had mental health issues. There was some period of time in 2016 where he was competent enough to plead guilty. But 8 years later, when he's being evaluated to determine under the whole 4243 regime, whether it's the time for him to be re-released into the public under, you know, conditions or whatever, at that point, he is found to be suffering from delusions, and I think also antisocial disorder at that point as well, that there was no series
At
of
that time, but he was
Yes.
subsequent to that time released upon recommendation of the director of the facility in agreement with the court that ordered his release. And after that time, no longer at any time found to be suffering from delusions. But these limits that were placed, they have no time limit. They essentially, it's a lifetime sentence subject to these conditions that are possibly related, possibly not related. There's nothing in the statute that says that there's, other conditions can be placed.
Other conditions could be placed if there was a subsequent thought that he needed to be brought back in, just as they were in 2016. It's a, I almost lost what I wanted to answer from you there.
It wasn't a question.
Unfortunately, mental health
okay.
is, I'm sorry, I'm sure you'll remind me, Judge Berner. if
I just
need
wanted to know if there was a subsequent finding of delusional behavior or thoughts after he was released upon recommendation of the director of the facility and an agreement by a judge who released him, if at any time after that there was a finding that he suffered from delusional behavior
Between 2012 and 2016.
after he was released.
Right, in that time period, not until he committed the crime.
Thank you.
Okay. He was
And after he committed the crime, there also wasn't a finding that he suffered from delusion.
long enough to get the guilty plea, it seems.
Was there ever a finding that he suffered from delusional behavior after he was released by the judge at the recommendation of the director of the facility?
He succeeded under the program between 2012 to 2016.
Was there ever a finding, yes or no?
Not in that time period. If it had been yes, he would have been revoked at that time. But here we are in
Can I,
2020.
can I come back to this question of what it means to be a regimen of medical, psychiatric, or psychological care or treatment? Perkins sort of instructs us that this is sort of a iterative process with the doctor and the district court. And it seems as if the doctor has to agree and the judge has to agree on what those conditions are in order to determine that he can be safely released.
Right.
And so I guess sort of what I'm trying to get at is it seems like in this context, what the doctor and the judge reach at the hearing, we don't have the transcript for, is that the gun is a condition that's being imposed, or the lack of possession of a gun is a condition that's being imposed that like is part of this balance of like he can get out, but if he's going to get out, he can't have a gun, among other things. Tell me why we think that sort of lesser restraint on liberty. I mean, because another option would have been to say, we think he continues to be, a danger, and so we're going to leave him in. Why is that lesser restraint on liberty sort of not part of treatment and care where like institutionalization is part of treatment and care? It seems like once we sort of acknowledge that restraints on liberty can be part of treatment and care, certainly we can totally institutionalize him, right? We can put him in a group home, which is like sort of a version of institutionalization, but with softer restraints on liberty. That why this like other restraint of liberty, that is like you can't have a firearm, couldn't be considered part of sort of a, quote unquote, prescribed regimen of medical care and treatment.
Well, it does seem like, again, they're trying to set Mr. Rooney up so that he could have been successful. And so with the guidance of the medical health professional who came into the court, I'm assuming that the procedure that was followed back in 2014 and 2016 was the same as we followed in 2024, which is the judge sets conditions or made her determination based on the advice and counsel of the medical health professional. And there's another medical term, titration, where we build up toward ultimately, if it needs to be institutionalization, that's what it is. But there are measures short of that, at least it was thought in 2012, where a restriction on liberty, but a limited restriction on his liberty would suffice. And that was a restriction on his ability to have a firearm.
Can you comment just briefly on the sort of last point? In 2012, you might well imagine that an individual would readily agree to a condition of not possessing a firearm in order to, if that would be what would tip the balance. We typically require challenges to conditions in the supervised release context and otherwise to be raised at the time of that order, and these sort of collateral attacks at the time of revocation are generally not permitted. Do you have a take on that? I note that you haven't argued it, so there's probably a waiver problem, but
Right.
bracket that for a minute. Is that the right way to think about collateral attacks on these types of treatment conditions?
Well, it did come up when we were talking through this at the office, and, you know, obviously, had we raised it, there would be a waiver argument that because Mr. Rooney did not challenge that condition at the time it was imposed in 2014, again in 16, that he's waived the challenge to it. But again, I guess to come back to what we have argued, it is reasonably related to all the conditions that were put on Mr. Rooney to try to ensure that he remained at liberty so long as he was not an unreasonable threat to the physical well-being of individuals or property. And unfortunately, he did not succeed. So, it
All
looks like
right,
we're about out.
thank you very much, Mr. Travelday. Ms. Albro, you got something else? Ms. Albro?
Thank you, Your Honors. I just wanted to address a bit about what Judge Berner brought up that I didn't get to in my opening, and that's about the supervised release statute. It was, in fact, considered and was part of the 1984 Comprehensive Crime Act, and it on 5 different occasions refers to order as an explicit condition of supervised release. So it authorizes the court to impose other conditions as well. So even though it gave some guidance on specific conditions that could be imposed under the supervised release regime, it did not limit the court on what it could impose. It provided guidance and said, you can impose other supervised release conditions. So under strict construction, we would assume that Congress purposely left that out of the mental health statute. And as indicated, 4543 is not, a conditional release revocation is not based solely on dangerousness. And there are other statutes in place to address those kinds of issues without reading into the statute something that it doesn't say. And one of those things is prosecution. And as I mentioned earlier, because he's been deemed a mental incompetent and Mr. Rooney was a felon, he also could have been prosecuted under 922G without adding, you can't have a gun as part of his mental health treatment conditions. He also was prosecuted in North Carolina and was subject to numerous supervised release conditions, including mental health treatment, medication, what have you. So when he was released, instead of pursuing relief under an 8.5-year-old petition about his possession of a gun, he could have just gone on supervised release. He also could have been, a proceeding in North Carolina could have been brought under 4246, which Dr. Lloyd's examination and evaluation in the record is more geared to that type of proceeding. So it doesn't mean that someone with Mr. Rooney's condition is necessarily going to be out in the public being a hazard or a danger. If there are other concerns, there are many, many other statutory schemes which can address that. Also,
What about supervision? Is someone that's released under 4243 subject to supervision where they need to check in? I mean, is that supervision sort of part of what we describe here as a regimen of medical, psychiatric, and psychological care or treatment? I mean, this sort of like, the supervision that exists to sort of ensure compliance with the things that are supposed to be taking place.
and I hope I'm answering your question correctly. My understanding, and I believe I saw in the record, although I can't point to exactly where, I think it was a question that Judge Curry asked the doctor. the doctor thought that the supervised release would be suspended if if his conditional release was revoked. Is that?
No,
the
no,
que-
I mean, when he's released under 4243,
Yes.
does he have someone who is supervising him, a person?
The probation office.
Like a probation officer, right.
Which I think actually is part of the problem, because the probation office,
No, no, I know, but
unfairly to them, they aren't trained necessarily in
All right,
this.
but bear with me for a minute.
Yeah,
I
sorry.
understand, that's a different point. So the probation officer, is the use of a probation officer consistent with the, prescribed regime of medical care and treatment? I mean, because your argument might say you can't have a probation officer because the probation officer's not a doctor, right? And so are you arguing that that is beyond what can be imposed by the district court?
I didn't make that
Okay,
argument. And
so I thought that was your answer, that you can do supervision, right? I mean, they can supervise someone that's a 4243 releasee.
I didn't address that, so I couldn't really answer that.
So it seems like it would be normal to have a condition that would say, once a week you have to meet with the psychologist. And if they fail to meet with the psychologist, they can be revoked.
That could be put in a petition for potential revocation, correct? I'm out of time. Does anyone have further questions?
All right, thank you very much.
Thank you, Your Honor.
Ms. Albro, we see that you have been court-assigned, and we appreciate your undertaking that task. And we thank both counsel for their arguments. We will come down and greet counsel and go on to our next case. All right, our next case is Sarver versus Clayborn Senior Living. Ms. Moran?
Thank you, Your Honors. May it please the court and counsel, my name is Elizabeth Moran from Hall Booth Smith, PC. I represent the defendants' appellants in this case, Clayborn Senior Living and TCABC Real Estate Holding. I will probably refer to them collectively as Clayborn in my argument. Now, as the court knows, we're here on a case that involves a request to enforce an arbitration agreement. This was an agreement signed by Mrs. Sarver for her husband, Gordon Sarver, who suffered from dementia in connection with his admission to a residential care facility. I'd like to first talk of the several issues that we've raised. I want to first talk about the waiver issue, the court's finding that Clayborn waived arbitration by its activities in litigation. Now, since the Morgan case, we evaluate waiver a little bit differently because prejudice is no longer part of the equation. But Morgan reaffirms a couple of important principles here that I think are important for this case. First of all, a waiver is a knowing and intentional relinquishment of a known right. Second is that in evaluating waiver, you look at the actions of the party who holds that right. And then third, although probably more pertinent to some of the other issues here, the court reaffirmed that arbitration agreements stand on the same footing as other contracts. We don't bend over backwards to favor them, but by the same token, we also do not impose obstacles in enforcing
So
them that we
how
would
much
not.
deference do we give the district court's finding in its text order that your client acted contrary to the court's order on limiting discovery?
Your Honor, in terms of deference, the overall waiver finding is a de novo, and factual findings are given deference. The court's text order is very brief and simply says very much what Your Honor just said.
Right, well, tell us, I mean, your goal is to tell us why the court was wrong.
Yes. What the court found was, and I think to really evaluate this issue, you have to look at the period of time leading up to the motion for stay and the issuance of those subpoenas. And the three subpoenas was the only specific thing the court cited in its text order in its finding of waiver. So from the beginning of the case on, it's clear that Clayborn was consistently asserting its right to arbitration. And it was kind
So
of.
why do you say that? That doesn't seem right at all to me, right? It seems like what it says is, we're gonna do this litigation, but we reserve the right. We're not gonna invoke it now, but we wanna reserve the right to invoke it later,
Yes.
right? So we want a chance to have a second bite at the apple. That doesn't seem like to me that they get to do this sort of like side preservation. We're gonna go forward with the litigation. We're gonna engage in discovery. We're not going to assert this right to arbitration. And we know from the Supreme Court that this right to arbitration is a right to like avoid federal court altogether, right? Coinbase talks about this. The Supreme Court repeatedly talks about what the right is to avoid the federal court system, right? It's not a right to like wait until you start to get bad rulings and then pull the ripcord,
Yeah.
right? It's a right to avoid it altogether.
Yes, that ideally is the right. But at the time that
But
Clayborn.
it seems like to me that you have acted inconsistent with that throughout, right? And it doesn't do, it's not enough for you to say, it seems like to me, in your briefing, that like, we're gonna answer the complaint, but we're not waiving our right to at some point later compel arbitration. There's an affirmative defense here, and maybe we will invoke this at some point, right? That's acting inconsistent, it seems like to me, with what Coinbase describes as the contractual right to arbitrate.
Yes, Your Honor. Ideally, when you would want to move to arbitrate as soon as you can. But in the situation here, we have,
So why didn't your client do that?
this is a situation where Mr. Sarver was incompetent, and so the wife was signing the agreements on his behalf, which are other issues in the case.
The agreements, there were
But
two agreements?
with the residency and arbitration agreement, it's an agreement
And
with
your client
appendices.
had those agreements, correct?
The client had the agreements, and by her signature in the agreement, Mrs. Sarver, there's a notation POA. And so when you have an incompetent person who is being admitted or someone is signing for them, you have to be able to establish the authority of that person to
And
sign
did she have the
for
authority to
them.
sign that arbitration agreement?
Yes, I think for various reasons, which are the other issues in the case, she did have the authority to sign
How
that.
did she have the authority to sign the arbitration agreement at
She
the
had
time
the-
it was signed?
At the time it was signed, the power of attorney, which Clayborn did not have, it did not have the document. And to enforce the arbitration agreement and be able to establish that a contract was formed, you need to be able to prove that. They did not have that document. That is why they did not move immediately for arbitration. It was not found until much later. Now, that
Wasn't it their document that they had their contract? How did they not have their contract?
they had the arbitration contract, they did not have the durable power of attorney that Mrs. Sarver held for her husband that authorized her to sign, which is part of the proof in establishing a binding
But
arbitration
it
agreement.
seems like just an ordinary practice that you would have required the power of attorney at the time, but that's kind of neither here nor there. But, I mean, if you have the agreement and you know you have a right to arbitrate, it seems like that the remaining things that would just be a matter of proof. And I understand the reasoning in wanting to wait, but when you know you have the contractual right, I'm unclear as to why you didn't proceed straight away and then simply, and maybe you did, do discovery or propound interrogatories to establish the validity of the power of attorney.
Yes, Your Honor, without the power of attorney, which is an important part of proof of authority, not the only way to prove authority, but important part of the proof, Clayborn had to have a good faith basis to move for arbitration with a belief that she had authority.
But if she had signed the agreement denoting power of attorney, seems like that would be a fairly good faith basis to proceed.
Well, it's
And
a
if there's
matter.
no power of attorney, there's a statute, right? And so, like, maybe they don't apply, maybe they're arguments, but it seems like to me, you don't get to just sit on your hands and participate in the litigation and go forward and do everything that you do until you start to not like what's happening and then pull the ripcord. Like, that seems to be the problem. And we have some old cases that seem like a little hard here. I get that we say that. But the Supreme Court sort of describes what Section 6 instructs us to do when it says that prejudice is not a condition of finding that a party, by litigating too long, waived its right to stay litigation or compel arbitration, right? The question is just like, have you litigated too long? Because by litigating, you're acting inconsistent with the right that you're asserting, right? You don't get to just like do both and right, just hold this like hammer in reserve and just wait, oh, now the district court's not looking like it's gonna be so good for us, so we'll pull the ripcord now.
I would point out that, and because of the authority question is determined by state law, South Carolina law, South Carolina is when you have an incompetent person or someone who is signing for another, you have a non-signator, that the proof demanded in order to show authority can be pretty stringent. And so knowing that there was some kind of POA out there that they did not have, and I would point out that in the initial disclosures, and the parties in federal court were under a scheduling order, so Clayborn had to do what it needed to do to comply with the scheduling order. So it sent out some basic discovery, one of which was a request to.
In a contract action in South Carolina court, is the lack of authority to execute a contract part of the burden, or is it an affirmative defense? So in other words, if I enter a contract with somebody and I sue to enforce that contract, does my complaint have to show authority, or is it an affirmative defense to say the person who executed this contract lacked the authority to do so? I thought of it as an affirmative defense. You seem to be suggesting that it is a plaintiff's obligation in a breach of contract case to assert, to prove authority. I thought it was the reverse, but I confess I don't know South Carolina law on this question.
I do not have authority for that, Your Honor, but it would
But
be.
if it's an affirmative defense, then you agree that the argument you're making doesn't make any sense, right? Because you then don't have the obligation to prove actual authority. It's just an affirmative defense that might be asserted or not.
If it were asserted and there was no POA to be produced, that would be the end of the question. It wouldn't have mattered whose burden of proof it was, because without the POA, there is no proof whoever's burden it is. So as
But you've also raised a claim under a South Carolina statute that even without the power of attorney, that either as a third-party beneficiary or under the statutory language for a spouse, that this authority would exist. So, I mean, was that just a later discovered potential means of recovery for your client? Or, I mean, it seems like that would have been there from the very beginning of the action and would have informed the decision on when to move for arbitration.
The POA that, the notation POA, Clayborn was looking for a general durable power of attorney. And the one that Mr. Sarver signed could not be found because it was not recorded where he resided at the time. It was,
Did you have the healthcare power of attorney?
at some point, it was produced in discovery.
But you didn't have, so when you took this person into your care, in your facility, you had no healthcare power of attorney? You just took him without any, like, indication that there was a decision maker for somebody who was incapacitated?
It was in reliance on Ms. Sarver's representations that she was his
So
power.
you'll take a
of
person in
attorney.
reliance on those representations, but you won't rely on those representations for purposes of invoking the Arbitration Act? I mean, that seems like an arbitration clause.
Well,
That seems like an
that's-
odd, like, we get to rely on her over here for all these things, but we don't need to rely on her at all when she says that she is a power of attorney. Like, we can just ignore that.
Well, there's proof for legal purposes, and then there is what you do in conducting business, and I think that the two are separate, Your Honor. I see that I am into my rebuttal time.
Not
I
yet.
would-
No, you've got, that's,
Oh,
you're
I'm sorry.
still
Okay.
good.
All right, thanks.
Is there, I see the POA written here next to Mrs. Sarver's signature. I know that she, in an affidavit, alleges that that's not her handwriting and that she didn't write that. Do you know when that was written or who wrote that?
It was apparently written at the time of the signature. She says she did not write it. We do not know who wrote it, but looking backward at the time when the suit was filed, it was seen there was POA. The thinking was there is a POA out there. That was, request was made to plaintiff. Is there a POA? Nothing was produced. The general power of attorney was not produced at that time. It turned out not to be valid anyway because it was recorded 4 days after he was admitted. So that was
So
what.
even if she had a power of attorney at the time, it's admittedly invalid, and so she would have been unable to sign the arbitration agreement then?
Under the general durable power of attorney, but not under the Healthcare Consent Act and the healthcare power of attorney, which empowered her, a decision the court really didn't address at all, empowered her to do what was necessary.
Did you have the
to
Healthcare
admit-
Consent Act when you admitted this man into your facility? Was that within your authority? I mean, you say, you disclaim knowing anything about any of the power of attorneys. Did you know about the act when you admitted him?
I do not know what the facility knew at the time he was admitted.
But if it was a duly enacted law of the state of South Carolina, that wouldn't make any difference whether they knew about it or not, would it?
Well, you're deemed to know the law. So the act existed at the time, yes.
All right, well, you are into a little overtime now, so you've got some rebuttal time. We'll now hear from Mr. Quinn.
Okay, thank you, Your Honors.
Good morning, Your Honors. May it please the court, I'm Elliot Quinn. I represent the estate of Gordon Sarver. I would start with touching on some of the points that Your Honors raised a moment ago. Judge Agee, first your question as to deference. Understand that legal determinations made by the district court are reviewed de novo. Factual determinations, though, are entitled to deference. And here, as to your question about violation of the stay order, that is entitled to factual deference in terms of finding that there was a violation. The lower court, yes, there's a text order that indicates it was violated. There's then a motion for reconsideration in which appellants outlined in detail why they contended that that was excusable and was a mistake. District court reviewed all of that and yet still made the factual finding that there was a waiver, that they had engaged in this conduct, they had violated the stay order. So would suggest
The
that
second order doesn't say very much.
Your Honor, I also wish that I could come before you with a more detailed order. And I am, Your Honor, as are you, I'm kind of left to read the tea leaves as to why we have two text orders in the way we do. And I'm happy to give you my thoughts there, but they're nothing more than my guesses. And then, Your Honor, turning
Well,
to...
they seem to be making the argument, setting aside what we've already discussed, they seem to be making the argument that we thought that Mrs. Sarver and her counsel had agreed that we could engage in this limited discovery. And there are 3 specific consents, it would appear, to do so. And that then after that, Mrs. Sarver, through counsel, which I presume was your firm, said, we were never aware of this before, and now this is a violation of the order that the court has entered, which seems, that part at least seems sort of dubious to me.
And Your Honor, if I can walk through the timelines and the facts there, we have a situation where opposing counsel sent over Mr. Sarver's attorneys, my firm, these subpoenas and indicating that they were going to serve these subpoenas if we did not object. Again, this is all before we get to a motion for stay being filed or a stay order being entered. Of course, we don't have any issue with opposing counsel obtaining medical records. We contend this case should remain in district court. They would be entitled to do that. We don't have any objection. And actually, it helps our position because it's them engaging in further discovery and them in basically availing themselves of the court. We don't want to be in arbitration, so if they want to continue to engage in acts of waiver, we will let them. And then, Your Honor.
But the court granted the motion to stay discovery 2 days before your colleagues signed the waivers.
Well, again, Your Honor, if they want to engage in this, all we are indicating is we're not going to raise any objection to this. If you want to issue these subpoenas, then you can do so. We don't have any objection to you obtaining his medical records. We cannot, though, allow them around a court order. If they're going to go ahead and issue the subpoenas in violation of a court order, then they are violating the court order. We can't excuse their violation for them. And at no point had we ever indicated that we consent to changing or agreeing to forego the court's order. The only thing we had ever...
It seems like a pretty slick rationalization after the fact.
Your Honor, I would return to again, I would suggest that their position seems to be that we need to save them from themselves. We owe them no obligation to save them from themselves. If they are going to engage in this conduct, if they are going to send subpoenas, have at it. We don't want to arbitrate. We want you to have waived your right to arbitrate, to have continued to do that. So agree, Your Honor, it is an odd situation in that they are presenting us with this, but again, would suggest we have no obligation to save them from themselves, and if they want to do this, they are counsel for that party, and they are obligated to represent that party. We don't owe any obligations to that party. Your Honor, I was then going to turn to Judge Richardson's questions as to, this idea you can't just preserve the right, you can't just allow it to sit there and say, we're going to use this as our backup, but we're going to go forward trying other things until we don't like where we are. And here they did. They got things that they would not be able to get in arbitration.
What do you understand? I mean, there's one old case, maybe it's no longer good after Morgan, but it does suggest that this idea, as long as you persist in your assertion, right, as long as I just write at the end of everything that I do, I have a right to arbitrate and I might one day invoke it, that maybe somehow preserves that right, and that's what maybe the court suggested is persisting in your claim. What's your response to that argument? That seems to be, in essence, sort of the main argument they're making against waiver here, is that, by putting this caveat in our answer and the things that follow, that caveat, is enough to hold on to the right. And, there's some appeal to that. Help me understand why that's not right.
And Judge Richardson, I would say, and I can't tell you the exact moment, but for a certain period of time, sure, that makes sense. Your client needs to collect documents. You've just gotten into this case. You need to preserve. And if you have opposing counsel on the other side that is immediately wanting to take depositions and go through discovery, sure. But at some point, you have to have gotten to this position where the opposing party has allowed so much delay and has engaged in conduct where they've actively participated in litigation, they've availed themselves of the federal court and the judicial process, and then that has caused the switch over to just simply sitting there and saying, I'm preserving it, is no longer good. And Your Honor, it can't be that you can get up to the eve of trial. We are picking a jury, and you come up and say, well, I've been preserving this whole time. Turns out.
It's been in a footnote in everything that I filed, but we don't like how the first half of trial has gone, and so we're going to invoke it now.
Turns out I want to invoke it now. And Your Honor, I'd say that a main component of that, and part of it's got to be time, but another part of it has to be, have you engaged in actions that are inconsistent with your right to arbitration? Discovery, deposition, subpoenas, what have you done before the federal court? And that must cause that switch. And what I was mentioning a moment ago.
Read this line. I'm not exactly sure what to do with this line from Morgan. But this line from Morgan seems to say, a party by litigating too long waived its right. That seems to suggest from the Supreme Court that time actually does matter. Maybe it's not sufficient on its own, but it does seem like time is a pertinent consideration. Is that how you read this line out of Morgan?
Your Honor, that is how I read that line, and going back to your questions a moment ago, I can't tell you if it's a week, a month, or 2 months, but there has to be some amount of time, even if the party isn't actively litigating, that you have allowed the case to proceed so long in court that you have now waived your right.
And you also agree that you've allowed it to proceed in court after having knowledge of the arbitration agreement. If for some reason, right, you've got a legacy company or the like, and they don't have knowledge, but if they don't have knowledge, they wouldn't be persisting in the right to begin with. They would then show up and say, hey, we just found this agreement. It just came out in discovery. We are now going to assert it immediately. In that instance, time wouldn't matter, in your view, because there would be a lack of knowledge, and you can't unknowingly waive it.
I agree, Your Honor, and then you could put something in the record, an affidavit. We discovered this agreement existed on this date. And I would mention, Your Honor, to that point, some of the cases cited by opposing counsel as to this issue, they want to conflate this power of attorney with those other cases. They all dealt with the party did not yet have a copy of the arbitration agreement. That is very different from this issue of did we have a copy of a power of attorney. Here, they had the arbitration agreement.
Do you have a view on whether this authority to execute a contract is an affirmative defense or part of the plaintiff's burden in a standard breach of contract case?
I would suggest it's an affirmative defense, Your Honor.
Suggest, real answer is you don't know either.
Well, no, Your Honor, my recollection of South Carolina contract law, going back to its most basic, is offer acceptance consideration. That's all I need to show, and then a breach.
But you might say acceptance includes a subcomponent, right? That it can't be acceptance by a random. You and I can't enter a contract with my law clerk, accepts it, right? The acceptance has to be by somebody who is pertinent, right?
Then, Your Honor, you do, and that is the complicating factor in my mind as well. You get into this issue of we don't actually have just two people involved here. Right. Yep. We have the third. And then, Your Honor, so what I heard after I talked about they availed themselves and obtained things they wouldn't get in arbitration, what I heard here as the reasoning was that they did not yet have a copy of the power of attorney. And Your Honor, I would suggest that that doesn't get them where they need to go for multiple reasons. First would be, if having this power of attorney is so important, they would have asked for it at the time of entering into the contract. Somebody noted POA on there. They should have asked, we need a copy of this so we can determine that we are actually entering into a contract.
I
But
thought you would have led with their own contract showed power of attorney, and that would be all they would need to allege is their reasonable belief that acceptance was witnessed by that part of the contract before you would go on to anything else.
Thank you, Judge Agee. That's where I was going to head next, was you could ask for it. You could also just move based on the notation of POA. You also, as you indicated earlier, Judge Agee, could have asked to engage in limited arbitration-only discovery and asked, produce copies of any power of attorney. I submit to you that my client, or the personal representative, Ms. Sarver, did not have copies of this power of attorney. Actually, she did not know of the general durable power of attorney. So that's why it wasn't produced in the discovery that did occur. And then, and I believe Judge Agee, you touched on this, it's also unavailing because what I heard opposing counsel say a moment ago was, well, they needed a good faith basis to move to compel arbitration. But they have third-party beneficiary, equitable estoppel, and the Adult Healthcare Consent Act that they are all using as basis for compelling arbitration. And today, they have now conceded away the general durable power of attorney and are only proceeding on those three. So those must be a good faith basis on which they could move to compel arbitration.
Well, I also find it notable that you filed your complaint in May of 2023, served it in very quickly, and then in the answer, one of the affirmative defenses is arbitration, and that was in June. So there was knowledge that there was arbitration, there was knowledge that that was an affirmative defense, and yet the motion to compel was not filed until the following March, so 10 months later. And in the interim, there was a significant amount of discovery, not only these subpoenas, but there were depositions. Were there not at least one deposition?
You're correct, Your Honor. There were three depositions. Three depositions noticed by plaintiff's counsel, by Mr. Sarver's counsel, but in which, all three of which, appellant's counsel also questioned the witnesses.
And was there any notation or on the record or saying we're doing this under duress, or that we're required to do it, that we have no choice, but we still think we should be arbitrating?
And this, Your Honor, goes back to Judge Richardson's point about preserving. Maybe they didn't even preserve it well enough to the extent they can say they did, because no, Your Honor, there was not. There is nothing, any indication that we object to this, we think we have arbitration rights, but we aren't ready yet, so we're only allowing this, preserving that. Additionally, Your Honor, my firm, on behalf of Mr. Sarver, we issued, I believe it was either 5 or 6 subpoenas to obtain documents. We did receive an objection from opposing counsel to those subpoenas. That objection was limited to their reading of one of the discovery rules of the Federal Rules of Civil Procedure, and in no way mentioned any arbitration right, which again would go to they are not preserving this if they think they have it. If no further questions, I can turn to other items. There are a number of additional issues on which opposing counsel contends that arbitration should be compelled here. I would note that
If you prevail, I'm not telling you to stop talking, maybe I am, but I'm not really. If you prevail on waiver, we don't have to sort through the various powers of attorney and statutory authority to enter the agreement.
if the appellee prevails on waiver, you do not need to deal with any of the other issues. If the appellee prevails on the meeting of the minds issue, you would not need to deal with any of the other issues. Those two would dispense with all of the others. And then if I was to turn to all the others, and Your Honor, I will take your veiled suggestion. But if I was to turn to all the others, I would suggest with each of the others, there are numerous preservation problems. that are an issue for each of those. And then on the merits, as we've dealt with in our brief, each of those don't get the appellants where they claim that they get. So if we're talking about third-party beneficiary, well, the appellants are applying old law that is no longer good law. Under South Carolina's third-party beneficiary law and under South Carolina's equitable estoppel law, Mr. Sarver just obtaining a room.
Well, the district court never got into this, did it?
Your Honor, the district court never did. And Your Honor, I would suggest that were you to disagree with our position on waiver and meeting of the minds and the district court's position on those, you certainly could send it back for the district court to deal with those other issues, although you also can review de novo and could deal with those.
Because you have not really argued that the durable power of attorney provided a basis here. Like, that seems to be what the district court relied on. That seems to be wrong. You have lots of counter arguments to that, the healthcare power of attorney, the statute, all of those different arguments. But you're not arguing that the durable power of attorney actually gave her authority.
Your Honor, the district court found that the durable power of attorney did not give Mr.
Right,
Sarver
I'm
authority.
sorry, I just had that backwards. You're right. Yep.
And then, Your Honor, would suggest, and I.
Because it was recorded, it was not recorded in the appropriate locality.
Both, it was not recorded in the county in which Mr. Sarver resided, and also it was recorded after the arbitration agreement was entered into, and the law requires that it be recorded prior to that. So for those reasons, it is not valid, and I would suggest that reading opposing counsel's briefing, I believe it was in a footnote, they have now conceded, and they do not raise it as an issue on appeal. They have conceded that the general durable power of attorney did not provide Ms. Sarver with authority. They have to rely on the Adult Health Care Consent Act, third-party beneficiary, or equitable estoppel to get themselves there if they can show authority. If no further questions for the court, I'll yield the remainder of my time. Thank you.
All right, thank you very much. Ms. Moran, you've got some rebuttal time.
Thank you, Your Honors. I sense that it's important to talk about the waiver issues, but before going to that, I do want to make a quick point about Ms. Sarver's authority under the Healthcare Consent Act and the healthcare power of attorney as well. And the point I want to make is that.
But I assume you would agree if we found that the district court did not err in terms of the waiver issue, there's no need to get to anything else.
Correct. But should the court get to that issue, the important thing to remember about that argument is that under that statute and under the healthcare power of attorney, if an arbitration agreement is necessary to obtain the health care that the patient is looking at, then the arbitration agreement is within their spouse's, their designee's authority to enter into that agreement. So if you look at the Coleman case and the Thompson case, in those cases, the arbitration agreements were optional. They were opt-out arguments, they were voluntary, did not have to sign to be admitted to the facility. This case stands on different grounds because it was not an optional contract, it was a condition of admission. So because it's a condition of admission, it's necessary to obtain Mr. Sarver's his healthcare admission to this facility, and therefore Ms. Sarver has the authority under both the Healthcare Consent Act and the HCPOA to do those things. Now, going back to the waiver issue, and I want to make sure to certainly answer any questions the court has, but a couple of points I'd like to point out is that the subpoenas that were issued, this was after the motion to compel was filed, and it I think as the court has maybe alluded to, there was a lot of discussion back and forth leading up to that. There was a flurry of emails about a discovery deadline coming up and concerns about getting discovery done while the motion to compel arbitration was pending. What happens if arbitration is denied and we haven't done discovery? Concerns like that. At the same time, defense counsel is concerned about.
And there is a way to solve that, right? You can stay it.
Yes. So what happened was there were these emails back and forth. Defense counsel proposed a stay. Plaintiff's counsel would not agree to a stay. Towards the end of the day, defense counsel files the motion to stay, which requests a stay of the discovery deadline or stay of discovery. It's not quite clear. But anyway, that motion is filed, and then moments later is when plaintiff's counsel emails back and says, we will agree that your continued participation in depositions will not be argued as a waiver. I'm paraphrasing a little bit. Defense counsel understood that to say.
Did you
we-
make these factual arguments before the district court on the motion for reconsideration?
In the motion for reconsideration.
And the district
yes.
court made a factual finding on that issue?
The district court simply denied the motion for reconsideration and said, it didn't address any of those circumstances. It
But
just
the
said.
documents, these emails were in front of the district court?
Yes, so you have there are a number of important emails. One is an email from defense counsel to her paralegal saying, okay, we can do these subpoenas now as we have, there's an agreement that discovery will not waive arbitration. So her understanding is that there's agreement that
The
discovery
paralegals- The
can.
paralegals understanding?
No, the counsel's understanding. She understands that discovery can proceed without the waiver. And then she sends these subpoenas to, the copies of the subpoenas to plaintiff's counsel. You know, here, we're planning to do this. Let us know if you object. And then plaintiff's counsel signed waiving any objections.
I tend to agree with you that all that is a little on the squirrely side, but, you know, this comes after a fairly long delay since the filing of the suit, and I think that may be probably the greater difficulty here is active participation in the suit prior to the issuance of these subpoenas, while there was the capacity to have asked for arbitration from the first day.
Yes, I do want to emphasize that Clayborn's participation in the litigation was as minimal as they could do to keep in compliance with the court's orders. Did not take any depositions, did not file any substantive motions, and I see my time has expired.
All right, thank you very much.
Thank you, Your Honors.
We're going to come down and greet counsel. We're going to take a very brief recess. And so if you're counsel for our remaining cases, don't wander too far.
The Honorable Court will take a brief recess.
Our next case, United States versus Jenkins and a few others. Mr. Beers, we'll hear from you.
Thank you. May it please the court. My name's Paul Beers. I'm from Roanoke. I represent appellant Jenkins. Here with me is Cecilia Englert from Alexandria. She represents appellant Brooks. I want to thank the court for appointing me to represent this gentleman on such an important appeal. It's important because I think the government in this case is trying to push the boundaries of RICO enterprise, that concept, beyond any other case they've cited, and I think erroneously. Yes, Your Honor.
Mr. Brooks is the one that has the attempted murder.
Yes,
charge.
Your Honor, that's
Okay,
correct.
just want to make sure I'm on the right page.
And there's another appellant who elected not to be here because the arguments are overlapping on count one, the conspiracy count. And the issue is quite narrow. It's whether or not they've proved the essential enterprise element. The parties agree on the test, and we agree this case rises and falls largely on interpretation of a 2009 Supreme Court decision called Boyle. And we agree on the racketeering issue here. I mean, there's no question the appellants were engaged in a racketeering predicate, that is drug dealing in this Franklin, Virginia. There's no question they knew each other. There's no question that some of them were related. But our point is they didn't prove that this group, this clique, these group of friends or family constituted an enterprise. They were not a gang. In fact, we had a testimony from one of the government's witnesses on page 818 and 819 of the record. It says they're not a gang. They didn't operate as a gang. They know what gangs are. There are plenty of gangs in that part of coastal Virginia. There are Bloods and there are Crips, but it's clear, there's no dispute in the record, this was not either a Blood or Crip affiliated entity. It's not an entity at all.
In fact, weren't the defendants, some of them Bloods and some of them Crips? Weren't they from different gangs?
Several of them were Bloods, Your Honor, including Brandon, who they say was the leader of this so-called enterprise. He was a Blood.
Got
I
it.
don't think there were any Crips.
But they were in different subsets
Of Bloods.
Bloods, some of them.
Yes, that's correct, Your Honor. And there's also a Crips affiliate in that town at this time called the Double O. So you had that going on, that dynamic, Crips against Bloods, we've all seen that. But this wasn't that. It's not an enterprise. Largely, I mean, the reason you know it's not an enterprise, the word enterprise itself implies they're in business together. It's an enterprise. They're not in business together. They were independent drug dealers, okay? So if you go out to an open-air drug market in any of our cities, you'll see different people out there that know one another selling drugs, selling crack cocaine, for example. That doesn't make them an enterprise just because they know one another and they have relationships with one another. They're independent sole proprietors. And that is the most critical problem with the government's case, why the judge should have granted the Rule 29 motion. They didn't go beyond that and show any kind of identifiable structure to any extent. They showed no rules, no initiation rights, but most importantly, they showed no commingling of drug profits. They didn't share losses, they didn't share profits. They can't be an enterprise. Justice Alito tells us that in Boyle in his footnote 4. He said, of course, if you have independent venturers, they know each other, but they're operating independently, that's not an enterprise. May or may not be a conspiracy, but a conspiracy under the Controlled Substance Act is very easy to show. The crime's complete upon agreement. We don't even need an overt act. But as the Boyle court says, and this court has said, post-Boyle, there needs to be more than a conspiracy. There has to be proof of an enterprise. So that's the most essential problem. That's count one. Count 4 only concerns Jenkins. Count 4 is a substantive crime under Vicar, attempted murder. It's actually under the same subsection of the statute, 1959A5. In that case, he was convicted of attempted Vicar murder 14 months following Brandon's death. So the conspiracy is limited to a 3-day time period. I should have pointed that out at the outset. December 17 to 19, 2017. That's count one. It's a 3-day so-called alleged conspiracy. Again, no proof of enterprise, so they should have lost that. The judge should have granted the motion for judgment of acquittal. On count 4, it's 14 months later, in February of 2019. At that point, you have no continuity. The Supreme Court says continuity is critical to an enterprise, and you have some structural differences. First of all, they say it's all about Brandon.
Now, this is after one of the other, not a member of this group, we'll call it, but one of the other, maybe it was a Crip.
He was a Crip.
Posted a video that they thought was demeaning to was it Brandon that was killed first?
Yes, Your Honor.
Okay.
Brandon,
That's the right time frame, right?
the court's timeframe is perfect. The killing of Brandon
Is that,
happened.
is that evidence that at least the double O's thought that Brandon's crew was like sort of a thing? It wasn't like a bunch of sole proprietors, right? I mean, they sort of say the scoreboard's 0 to 1, right? Or whatever that precisely the line was. I mean, that suggests that, you know, the Crips at least thought that this group, what I'll call Brandon's crew because it's just an easier way of referring to it, might have just been Brandon's group of, you know, individual actors, but that they were sort of an enterprise. I mean, why isn't that, I understand you're making a different argument about this point, but why isn't that some evidence that a jury could use to sort of say, like, listen, people that were acting in this area at the time who knew like what was going on, sort of considered that group to be a group, like not just a bunch of sole proprietors, but like to be a group. Like I actually thought this was some of the, you know, more interesting evidence, that like there was real evidence of people on the ground at the time who had real interactions, and they're purporting to say, like, this is a group we compete against and we're winning 0 to 1. Tell me why I don't interpret that language, or more importantly, why a reasonable jury couldn't understand that language in that way?
Thank you, Your Honor, for the question. Of course, they didn't testify. That was a Crip that made the video, the taunting video, the happy birthday video. So he didn't testify. That just shows that, you know, he's taunting Edward, Brandon's brother, and Brandon's friends. Hey, we killed your buddy.
He's doing it in a way that shows his impression of what reality is, right? Right? It's not, you know, maybe it's not for the truth of the matter asserted, right? But he's showing that, like, his impression, his understanding at the time is that this is a crew, right? And we're competing against them. We're the Crips, they're the crew, we're the double O's or whatever it is, they're the crew, and, like, we're winning. That
Well-
sort of feels like we got a team on the other side.
Well, thank you. I understand the court's concern and question, but of course, Brandon was in a gang. He was a Blood. In fact, he was the big homie of the Bloods, and the guy taunting him with his video is a Crip.
Totally think a jury could take that version of the facts, right? But I don't get to do that, right? I sort of have to take the facts and
Yes,
sort
Your
of
Honor.
say, could a jury hearing that, I mean, we got other facts here, but I'm just focusing on one because you brought it up. Like,
Yes, Your
if I just look at a jury and say, could a jury understand that as some evidence that there was like an organization on the other side, even if just a loose affiliated, as compared to a group of sole proprietors? I don't know, that seems like some evidence to me.
Well, a group of sole proprietors can be on good terms with one another and be friends and have rivals over here. It still doesn't make them in business together. It doesn't have them sharing the profits of this racketeering activity. The enterprise has to engage in a racketeering activity as an enterprise. Here, the only racketeering activity alleged is drug dealing. This so-called enterprise is not engaged in racketeering activity as an enterprise. So it doesn't change that fact. But again, count 4 is even weaker because by that point, there's no more railroad. As soon as Brandon is murdered in 2017, the railroad is vacated. The railroad was the house that they say is the base of this so-called Brandon's Crew enterprise. That's gone. Brandon, of course, is gone. And in fact, everybody else disperses except Edward, his brother, and my guy, Jenkins, who's still around. Is there evidence they're still drug dealing? Yes. But so what? The Supreme Court says there has to be continuity, has to be an ongoing unit. This concludes my portion of the argument. Thank you very much.
All right,
Unless there are any questions.
thank you, Mr. Deers. Ms. Engler?
May it please the court. May it please the court. I'm Cecilia Engler, and I represent the appellant Japri Brooks. I would like to spend my time to address Mr. Brooks's conviction for attempted murder. And my argument centers on the government's failure to prove that Mr. Brooks had the intent to kill at the time that he fired 3 shots into a house at 3 o'clock in the morning.
So as I understand the government's argument, it is that Mr. Brooks went out that night with the intent to kill this fella Tooth, and that he shot up Tooth's mother's house, and that this intent to kill Tooth sort of transferred to his mother. Is that what you understand the argument to be?
My understanding, yes, and I think that changed a little bit. In the trial court, in closing arguments, the government actually, after the jury was instructed that the jury has to find intent and a direct act, the government argued that there was intent to kill Tooth, and I'm not sure that it was made very clear to the jury that this intent was transferred to the mother, so that there was actually, at the time the shots were fired, an intent.
Was the argument made that, well, maybe Tooth was at his mother's house, so he would fire shots on the chance that Tooth had stayed at his mother's house?
There was not that argument. I think that there was a disconnect, that there was evidence that Mr. Brooks and others were driving around the neighborhood looking for Tooth.
And do you agree that that they had an intent to kill Tooth? It seems like to me there are 3 possible pieces here. One, you could have said there was never an intent to kill Tooth. That doesn't seem to be the argument that you are making or really could make. You could make the argument that there was no act toward the commission of that. Or I take you to be making that there's no connection between those two, right? That at the time of the shooting, it wasn't motivated by the intent, right?
So-
Help me understand, because it seems like to me here, unlike cases like Thacker, for example, there was absolutely evidence from which a jury could conclude an intent to kill Tooth, right? So this isn't somebody that they didn't know. They had an absolute intent to kill Tooth, and they took actions that at least arguably were toward the commission of murder, right? That was shooting into the house. The question is the connection between those two, and you've sort of argued this, right? That sort of seems to me to be like a quintessential question for the jury, right? As to whether, the actions taken were connected to the intent to kill. The cases that you've relied on, like Thacker, I think don't help you, because those are cases where there never was any intent to kill anybody. Fine, we don't have that. Why couldn't a jury conclude here that I'm driving around looking to kill somebody, in a particular person named Tooth? I see the house where Tooth at least at one point lived. Whether he does now or not, I don't know. And I shoot into the house. Why can't a reasonable jury in that context say that, like, that action was taken in connection with the intent to kill Tooth? I understand your argument is that, like, no, these bullets were fired high. All right, but like a jury doesn't have to believe that, I don't believe. So help me understand why I don't make this why a jury couldn't make this connection? I might not make it, but why couldn't a jury?
So, Judge Richardson, you're correct that our position is the third of your three different scenarios. And that is that at the time Mr. Brooks fired the shots, that he had to have had the intent to kill someone. And that someone would either be, in the facts of this case, either Tooth or his mother. Now, firing shots into that house at 3 o'clock in the morning, when Tooth did not live there, there's no reasonable chance that he was going to kill Tooth by firing shots into that house.
Why do we know that? Why was a jury required to conclude there was no reasonable chance that Tooth was there? What should I look at in the evidence to find that?
There was testimony that Tooth's mother lived there alone. There's no testimony that Tooth lived there. And firing shots...
That's an absence of evidence, right? But that doesn't preclude a jury from concluding that people often visit or live or stay for periods of time with their mother.
At some point, there's speculation, I suppose, but in this case, it was the government's burden to prove intent to kill.
Well, they definitely proved intent to kill. They needed to prove that it related to firing a gun into somebody's house. They had intent to kill. There's no doubt about that, right? But it's just the connection, and I just wonder why the jury couldn't draw that connection.
Well, I would posit an example of, let's say, Mr. Brooks is riding around looking for Tooth to kill Tooth. He sees Tooth's mother, say, in a car, and he shoots out 3 of the tires. And there's no reasonable chance that that's going to kill Tooth.
And I'd agree with you on that. Problem is, that's not what you got.
I think it's analogous, though, because if we're saying that someone's actions, they intend the probable consequences of their actions, all 3 shots were fired high up on the house.
Under your argument, I take it to be that under the Virginia statute, there would have to be sufficient proof that there was a specific intent to kill Tooth's mother in order for him to be convicted.
That's correct.
Is that the bottom line?
That is correct. That is our argument, and that the government did not put in any evidence of intent to kill Tooth's mother.
All right. Thank you very much.
Thank you.
You and Mr. Beers both have some rebuttal time. Ms. Taylor?
May it please the court. Kristen Taylor on behalf of the United States, the appellee in this case.
Why don't we start with Mr. Brooks? What's your best evidence of the specific intent under the Virginia statute?
Your Honor, as this court is aware, intent can be inferred by reasonable inferences drawn by facts that were proven at this case. What the jury heard was that Brandon Leonard was killed, and it happened a couple of days after an incident at a shot house that involved Brandon Leonard and Mr. Brooks. And the two of them, Mr. Leonard, Mr. Brooks, and one of the leaders of the Double O gang, the rival gang, got into it at this shot house. And during that incident, they drew guns at one another, and there were threats that were made between the two.
Let me go at it a different way. What's the evidence of, I'm not saying that this is necessary, but what's the evidence of specific intent to kill Tooth's mother?
Cynthia Barnes testified that she had been living at the South Street residence for approximately 18 years. E.J. Leonard testified that that was a well-known residence of Ms. Barnes and that everybody in the crew was aware of who resided there. In addition to that, Ms. Barnes did in fact testify. I know counsel stated there wasn't evidence, but E.J. Leonard testified, Cynthia Barnes testified that her sons had stayed with her frequently. And so there was a reasonable likelihood, after they had gone around the neighborhood looking for Tooth, that he could be staying there with his mother.
So do I take that argument to mean your point is that the intent to kill Tooth is what is at issue, you're not alleging, or you're not arguing, at least now, that there was a specific intent to kill Tooth's mama, but instead, there was an intent to kill Tooth, and they shot into the house with the at least plausible belief that Tooth might be in there, and that'd be enough.
That is enough,
Right?
absolutely.
In the same way that, if I had a specific intent to kill Judge Agee, and I went and put a bomb under his house and blew it up, the fact that he happened to not be there, wouldn't actually defeat an attempted murder charge.
Absolutely. And in this case, I think one of the most important pieces of evidence that gets kind of lost in the record is that witnesses testified that Mr. Brooks was in possession of two different weapons that night. He was in possession of a handgun, a .45 caliber, and he was also in possession of a rifle. So when driving past on the second pass, after they had gone out and looked for Tooth, and now left this other gang member's house, going out for a second round, driving by Ms. Barnes' house, he elected not to use the .45 caliber, but he elected to use the rifle that had higher capacity, more likelihood of striking, more lethal force, and he chose to shoot not just one shot up into the air, but he used a rifle and shot at least 3 to 4 rounds into the front of that house.
So what's your best Virginia case under the attempted murder statute where the defendant is not shown to have specific knowledge of the occupants of the residence?
I think,
Because I haven't found one.
I think it would be the cases, and there are a few cases where the defendants have not had it, and I think the Virginia law, it was at least the government's perspective, that specific intent needs to be specific intent to kill a person. That there doesn't have to necessarily be a specific intent to kill a particular individual inside of that house. So for example, there are Virginia cases cited in the government's brief or in the party's briefs where the defendant has committed an act of violence, for example, setting fire to a building, not necessarily knowing who's inside that residence.
Is that Hancock that you're talking about?
It's not Hancock, Your Honor. I'm sorry, that the name is, it might be Commonwealth v.
Well, here's kind of a bottom line question. I'm having trouble differentiating what you're arguing in this case for attempted murder, how that doesn't basically convert every prosecution under a separate Virginia statute for shooting into an occupied building into an attempted murder case.
I think there has to be a reasonable understanding or reasonable belief that there is a person present inside of that home at that time. And I think that's sufficient. In those cases, for example.
Well, what's your case that there may be one that says a person, but I thought that the cases said there had to be a specific intent to kill the person in the dwelling, and that's what separates the attempted murder statute from the shooting into the occupied dwelling statute.
I think that's absolutely correct. I think Your Honor puts it perfectly, and we do have that in this case. First of all, regarding Ms. Barnes, given the time
But
of.
to get there, the jury has to have concluded that because Brooks stayed there at some point in the last 18 years, that there was a reasonable chance that he would be there that night and then that they could murder him by shooting into the building. I mean, it seems like to me that has to be your argument.
That's correct, and I think that the facts in this case support that inference for the jury. There was enough evidence for the jury to conclude that. Given that Ms. Barnes testified that her son stayed with her at times, that she had lived there for a long time, it was the middle of the night. They had cased the neighborhood looking for Mr. Barnes. They were not able to find him, and on that second round, I think that the evidence suggests that they were driving past that house with the expectation that that could be the location where Mr. Barnes was. And when he shot the bullets into that house, that was his expectation.
So if we were to assume, simply for purposes of argument, that we disagreed with you on the attempted murder conviction, would you also agree that the related firearm conviction as to Mr. Brooks would have to be reversed?
Well, that is correct, because the attempted murder and native racketeering is the factual predicate for the 924C.
All right.
Can I ask you a question about the enterprise issue? In your brief, you lay out in pretty specific detail the features of the lowlives that support a finding of an enterprise with respect to that group: initiation rituals, hand signs, territory, shared criminal activity. But those features are largely absent from this group that you call Brandon's crew. They themselves didn't call themselves that, right? That was a sort of title made up by the government in the case. So how should we consider the lack of these structural elements, particularly given that all the cases that you rely on contain similar evidence to the markers of enterprise present in the lowlives group?
The main feature of this enterprise, and I think I'll start with its purpose, and it stems from the lowlives. I think it's fair, and I think the jury was free to infer that this enterprise was it was a continuation of what used to be the lowlives gang. That was the relevance of introducing the evidence of the lowlives and how they operated in Franklin.
So the fact that some of the people in this group that you call Brandon's crew used to be in another group that could possibly be considered an enterprise, that means that anybody, it's sort of like guilt by association. I'm involved with those folks.
Oh, no,
Because
but
it's not a perfect, it's sort of a Venn diagram. Some of the people were in the low lives, some of the people weren't, and then there's this group in the middle that you're calling Brandon's crew, but not all of them were in low lives.
that's correct. No, the understanding of the lowlives is just to help understand the relationships between the individuals who are in this
They're
new group.
buddies, right? They hang out at the same place. They're sort of like friends.
Well, they are friends, but being friends doesn't preclude them from being members of an enterprise. In this case,
Nor does it require them to be considered members of an enterprise. Being
But-
friends, that's not enough, right?
that's true. But what this court has recognized in the past is that to differentiate a conspiracy, a mere conspiracy, from an enterprise, there needs to be some structure, but there need not be much. And in this case, there is that bit of structure that is necessary for an enterprise to exist. The purpose of this enterprise, the reason that this enterprise existed, was to maintain and protect territory. That was the main purpose, and that was evident in how it related to the rival gang in that town. There was the 00 group that had an affiliation with the Crips, and there was this crew here that had an affiliation with the Bloods. The lowlives, the evidence that came in about the lowlives was that Brandon Leonard had a reputation, he had built up a reputation for being ruthless and for being violent, and that the lowlives marked and tagged their territory and that they used it to commit acts of violence. This particular enterprise moved in after Brandon Leonard came back from prison. He came with new blood associates. He came back to Franklin, and he retook over that territory. And his associates came into town, and they benefited from his controlling that territory. The currency.
So it's enough to find an enterprise to have individuals, assuming that we agree with you that the purpose was to maintain territory, which it's enough to simply benefit from one individual's control of territory to be considered part of an enterprise for purposes of the statute?
It is, because like I said, the currency in this case was that this territory was theirs, and they could use it to do with it what they wanted. In this case, many of them engaged in drug trafficking activity. And they did it with limited interference from the ops, or the 00 gang, the Crip-affiliated gang. They went to Railroad, they operated mostly out of Railroad before these shootings took place. Buyers came in and out. We heard testimony that this was a safe place. They were protected in that area, and they didn't have to worry about the outside interference.
Is there any case that you can point to that finds a criminal enterprise where, in facts such as these, where one member of the alleged group allegedly controls territory, the others allegedly sell drugs in that territory, but don't share any funds, don't share drugs, don't share a list of clients? The only thing that they share is the purpose, they don't even have a shared purpose to maintain territory. What I think you've alleged is that one person in the group has control over this territory.
That's not necessarily what the government is saying here. The government says that these individuals, this crew of Brandons maintains this territory collectively. That Brandon's reputation for violence assists in that, it facilitates that, but that this group collectively maintains the territory. And how do they do that? They act immediately, they mobilize immediately in response to acts of disrespect and in response to the ops getting, quote, out of hand. So for example, and we see this in this case, we see that, these individuals in response to 00 committing the ultimate act of disrespect in killing their leader, in immediate mobilization, a determination of who they believed were responsible, arming themselves and acting immediately.
Didn't all that happen after Brandon had been killed?
That is true, yes.
And so how did Brandon continue to maintain control over the territory after he was no longer alive?
Once again, I think these individuals maintain the territory collectively. Brandon, as the leader, helped establish that when he came back to Franklin from prison. He came there as having been a high-ranking lowlife member. He was a high-ranking Bloods member. His power and influence helped them to maintain control over that territory, but they collectively maintained it. And in order to do that, they needed to act violently. They needed to respond to acts of disrespect.
So what was
With
their
violence.
enterprise? Under the statute, you need an enterprise. What was the enterprise?
Absolutely. So in terms of relationships, we've shown that these individuals were related based on the neighborhood. This is at its core a neighborhood street gang. And there are two groups in Franklin. There's Brandon's crew and there's the 00 crew. And that's, again, evidenced by what Judge Richardson was talking about earlier with the scoreboard. There's a scoreboard here. There's two teams in Franklin, the 00 team and Brandon's crew. And these individuals who are in Brandon's crew, their relationships are defined on their past connections through the lowlives and their present connections with the Bloods.
Right, but Jenkins, Newsom, and Brooks were never in the lowlives, right?
That is correct.
I want to point out to you the language from the statute that says an enterprise includes any partnership, corporation, association, or other legal entity which is engaged in, or the activities of which affect interstate or foreign commerce. How does what you say is the purpose of maintaining territory in a neighborhood affect interstate or foreign commerce?
Well, interstate and foreign commerce is affected by their drug trafficking activities. We heard evidence that Dupree Brooks connected the group to a drug dealer who worked out of North Carolina, and that members of the enterprise, including Mr. Brooks, including E.J. Leonard, including Monte Newsom, who is also another member of this enterprise, including Mr. Jenkins, traveled frequently to go to North Carolina to retrieve drugs from this individual, that this individual came to the railroad house to provide drugs. So the drug trafficking trade, as well as the movement from Franklin to North Carolina, I think sufficiently satisfies interstate commerce. In
So
terms
you're
of
relying on the drug trafficking then as the enterprise, not the maintenance of the neighborhood as the enterprise?
no,
I'm
that's
just trying to get to the bottom of what's the enterprise.
absolutely
here.
no. I understand. No, we're relying on the drug trafficking to satisfy the interstate commerce piece of that. This is an enterprise that's associated in fact, which is allowable by the statute. And Boyle helps us understand how an enterprise associated in fact is defined and what is necessary for that. And that's relationships, a purpose, and longevity sufficient to maintain that purpose. I've discussed it at some length, the relationships between these individuals. They are friends. They are blood associates. Again, they're cross-set associates, which shows that this isn't just a Bloods organization at its core, because they're members of different blood sets. And so they're obviously connected through something else. And we submit that it's through the neighborhood connection. They want to maintain control of this area. And that goes to the purpose. The purpose of this association is to control this territory. This is the territory that they want to maintain. And how do they do it? They do it through mobilization and acts of violence in response to any acts of disrespect or any movement into their territory.
So
And-
before Brandon died, am I remembering correctly, he basically charged a commission if anybody else wanted to sell drugs in that area?
That's true. There was testimony that in order for any of the ops or the 00 to sell drugs in their territory, they had to pay him tithes. Which again, just exercise, it
What
wasn't,
about after he died?
that's correct. That's
Well, no,
correct.
I mean, after he died, did that practice continue?
No, the testimony didn't establish that or say that that didn't happen. But I think at that point, what EJ testified to was that even after Brandon died, this crew continued to sell drugs. They continued to act in the manner in which they were prior to Brandon's death. And again, what we
But
see.
didn't all of the charged crimes take place after he was no longer alive?
Yes,
And there were no longer any tithes after he was no longer alive?
that's what we're led to conclude, and I think that's what the
Well, there were
jury.
no facts presented to the jury to suggest that there were tithes after he had been killed.
That is true.
So how does this not squarely fall within Justice Scalia's footnote 4 in Boyle? A group of, describes it, it's easy to envision situations in which individuals engaged. This sounds to me exactly like his description, where he says there's no enterprise.
I think that the way that this court should look at it is differentiating this case from, I think what the court was describing in that case was more akin to Pinson. 4 very independent ventures happening where there were independent, in that case, not even conspiracies. The court didn't even find that conspiracies existed, but 4 very independent ventures, one individual kind of tying it all together, and those individuals really not knowing about what the others were doing, didn't really understand each other's motives or reasons for doing what they were doing. I think that's what the court was describing in that footnote. It's solely independent ventures where these individuals had no collective effort whatsoever. That is not what we have here. We have a group of individuals who are tied together in various ways, who are connected to this neighborhood, who are working to maintain and protect their territory from another group that is operating in that area who wants to come in and who clearly taunts this group and reminds them when they're down one via the evidence of the scoreboard. So I think that, and it makes sense that cases like Pinson don't qualify for an enterprise, but in this particular instance, where you have the Boyle factor satisfied, where you have the stated purpose, the clear purpose, and again, we see them acting to satisfy that purpose over and over again, even into February of 2019. What happened? We had the happy birthday video, we had the scoreboard posted, we had sharing that information. We saw that same mobilization in February of 2019 that we saw back in December of 2017. They got together, they armed themselves, they planned, they figured out who was responsible, they figured out where they were, and they carried out that attack. That ability to mobilize is evidence of a functioning unit, a continuous functioning unit. That is a unit. That's not just a group of friends. That is a group of people who have the ability to come together, mobilize, and commit acts of violence to further that stated purpose, to further the purpose of maintaining and protecting that territory from the others thinking that they can come in and get in the way.
All right, let me ask you one last question about a different defendant, Newsom, who has a conviction for witness tampering.
Yes.
What's our standard of review for that? And
For sufficiency.
I'm particularly asking, do we review that claim for plain error only?
Well, so I think there are 2 claims for Mr. Newsom. Anything related to the sentencing issue, yes.
Right, this is just for the conviction for witness tampering, not the sentencing.
You're right, Your Honor. There
No,
wasn't.
I'm asking, is
Yes.
it the government's position?
It is the government's position
review?
the plain error would apply because it wasn't raised at the Rule 29. And that's because the evidence in that case was extraordinarily clear that Mr. Newsom had in fact engaged in witness tampering.
All right, thank you very much.
Thank you.
So, Mr. Beers,
Yes, Your
do
Honor.
you or Ms. Engler represent Newsom?
No, a lawyer named Mark Diamond does, Your
Okay,
Honor.
all right.
Just a couple of points. The big picture here is the government has not cited the court anywhere a case like this where there's absolutely no evidence. It's not a blood organization, it's not a Crips organization, it's a bunch of independent drug dealers and succeeded in establishing that's an enterprise by itself. They're just not citing any cases. All their cases are obviously facially distinguishable.
What do you say, how do you respond to this argument about the purpose of the enterprise being to protect a particular territory so everybody can deal drugs freely, independently, but freely within that protected territory?
I mean, they may have, I mean, they're armed drug dealers, they protect themselves, but there's no evidence they were out, they act as an enterprise in a coordinated fashion to protect a particular area. Now, Brandon did by tithing.
But why don't we look at like what happens when Brandon's killed as
Yes.
sort of evidence of like what existed before he was killed?
Okay.
Right? And a jury might well say, right? I mean, sometimes in insurance cases, we say we can't look at facts after the fact to determine whether negligence occurred, but we don't think about that here, right? And so the fact that we have this coordinated response as a result of violence, doesn't that give us some evidence that they're not just looking out for themselves? I mean, you're just saying, oh, they're only looking out for themselves. That's not true. And maybe you want to say, oh, well, they did that just because they were friends. Maybe, right? But why couldn't a jury conclude that that also is evidence, right? We really defer to juries, right? And you might have very good arguments that might convince me had I been on a jury.
Yes, Your Honor.
Right? But what I'm looking at is like, couldn't a jury look at the response and say, that's actually evidence that supports that they collectively protected this area as a group, and that they would respond to incursions as a group?
Thank you for the question, Your Honor. Because people retaliate all the time against one another doesn't mean they're in an enterprise. If someone kills another one's friend or brother in this case, there's reprisal. That doesn't mean there's an enterprise. What's undisputed is that.
But that's just to say, like, you think that evidence isn't very good, okay, but it is evidence, right? Like, as soon as we start saying there's some evidence from which a jury could conclude, you have a response to it. I get it, right? Like, but that's not, we tend to do these types of like reversals, basically grant acquittals, in scenarios where there's like no evidence to support some element.
There's undisputed evidence, Your Honor. They were independent venturers. I think they've just conceded that. They were sole proprietors. These are drug dealers.
I'm sorry. What do you think conceded that?
I thought.
Like, I mean, you might be right, but I don't think there's any world that suggests that they just conceded that they were independent venturers.
They don't need to concede it because the evidence is clear. They were not. Brandon didn't front them drugs. They all individually went to their own source, and many times the same source, but they're not in business together, so it can't be an enterprise. That's footnote 4, and that's also Pinson. And after Brandon died, no one replaced Brandon. If it's a structure, there would be a replacement. No one became the new Brandon. The tithing stopped. People dispersed. They left town, and by 2019, there's 2 of them left. Edward and Jenkins. Yes, Your Honor.
At trial before the jury, was there an argument or evidence presented that the project of the enterprise itself and the purpose of it was to maintain territory? Was that presented to the jury, that theory?
Your Honor, I see my time is up. May I answer
Yes,
the court's
please.
question? Yes, thank you. I don't think it was presented to the jury, Your Honor. Neither Ms. Englert nor I were there. We were appointed on appeal, but I don't think that was presented to the jury. I think this is they just said, basically, as the court asked at the beginning, there's a lot of evidence about the lowlives, which is largely irrelevant because the lowlives, undisputed, were done over by the time Brandon came back from prison. There's no more lowlives. Thank you, Your Honor.
Thank you very much. Ms. Englert?
Just a couple of points that I would like to hit on. First of all, I believe the government was arguing that Tooth may have stayed frequently at his mother's house. I did not see that in the record. I believe Ms. Barnes testified she was asked if her sons had ever stayed with her, and she simply responded yes. Mr. Brooks, when he fired into that house, he was looking for Tooth. He may have been frustrated that he couldn't find Tooth. He may have shot as a warning, but at the time he made those shots, he did not have the intent to kill Tooth because he did not think he was going to be able to kill Tooth by doing this. He shot high up on the house and he stopped. He could have seen where the bullets hit. He could have shot lower. He didn't. He moved on. And the other reason we know that he wasn't thinking he would be able to kill Tooth, there was Edward, who was in the car in front of him. Edward testified that if he had seen Tooth that day, he would have shot him. He made no move in the house. He didn't shoot his gun into the house. The intent to kill is the essential element that separates this from Virginia's offense of shooting into an occupied building. In this case, to convict Mr. Brooks of attempted murder, the government had to prove that he intended to kill someone when he fired into the house. The government failed to make this showing, and therefore Mr. Brooks' conviction for attempted murder and his related 924C gun charge should be reversed.
All right. Thank you very much. I appreciate that. Court notes that Mr. Beers and Ms. Englert are court-appointed, and we want to express our deep appreciation to you for undertaking that task, because we couldn't function without it. And we're particularly appreciative of your continuing in this appellate advocacy when the government's a little short on funds. So hopefully you're going to get paid. All right, we're going to come down to Greek Council and move on to our last case. On up. And our last case is United States versus Adamiak. Mr. Larosier, did I pronounce that correctly? Yes, sir. Oh, good. All right, we're going to hear from you.
Thank you, Your Honor. May it please the court. When an indictment leaves every definitional branch of the statute open, we cannot know what the government proved or whether the jury was unanimous. It's not justice, and it's not lawful. The case turns on the most basic requirement of due process, and that be that an indictment fairly, without any uncertainty or ambiguity, inform the accused of what he must defend against. Here, the indictment never alleged how any of the charged items were machine guns or destructive devices, which are legal questions. 5861, the statute he was charged under, simply
So why
states.
didn't you ask for a bill of particulars, right? The way we do this in almost every instance is that when we're talking about the means of satisfying a given element, right, the question is you ask for a bill of particulars, right? That these are not separate elements, right? This is the Richardson versus U.S. and Shad versus Arizona. These are different means of satisfying a given element. Is this a machine gun? Or whatever the particular item is. And so typically we say you get a bill of particulars, and maybe the court grants it to you, maybe it doesn't, if you have a reason that you need to understand it, right? But it's not an indictment problem, right? I guess I'm a little confused at your argument, I confess.
Well, Your Honor, I think it is an indictment problem, and it's especially highlighted when all of the cases that the government points to in support of their proposition that the indictment is sufficient contain the specific definitional language that would make it clear as to how it was being applied. And, Your Honor, I
But
resist.
you understand it's a means, right? So like anytime you have, right, so take a 922G charge, right? So it's a little simpler, but you have to show that it's a firearm in order to convict under 922G. Well, there are quite a number of ways to convict somebody for having a firearm, right? So firearm shows up in a number of different ways. There are different definitions. Nobody thinks that you have to include which definition it is that applies because the element is that it is a firearm. The means of proving that might be, for example, that it is capable of expelling a projectile by means of an explosion, or whatever the first definition in there is. So that makes total sense, but no, I've just never, done lots of these, never seen the scenario that these means have to be laid out in the indictment. You might be able to come back if you have a prejudice problem and allege it in a bill of particulars, but I guess I'm struggling to see, and maybe you have examples where they did include it, but the fact that some indictments include more information, I will tell you, there are indictments that do not include it. And so I guess that's like not that persuasive to me. The question is like, where do I find a case where the means of proving a given element have to be included in the indictment?
Well, so, Your Honor, we're getting pretty down into the weeds of whether these are means or elements, and I would submit that these are materially different prosecutions. That a defending against a, for example, incendiary bomb, to use the language from an indictment that the government supported for the position that their indictment was sufficient, right? A destructive device, more specifically, an incendiary bomb. That's materially different than defending against a rifle with a large bore that is not for sporting. Those are materially different things that are the same, that Your Honor is suggesting is the same element in 5861. I submit that couldn't possibly be the case.
So you think every 922G prosecution that is done is also an improper indictment?
No, Your Honor.
Because there are different ways of proving whether something is a firearm. Your argument is that every 922, your argument would have to mean, I think your argument's wrong, I'm not hiding that, right? But like, it would mean that every 922G case is also invalid.
I resist that, Your Honor, because in 922G, the definitions aren't internally inconsistent. So the definitions in 922G build upon each other.
They are internally consistent, right? Because some of the definitions, some require able to expel a projectile by means of an explosion, and some specifically do not require that it be able to do so, right? I actually don't think that works at all.
I think that they're progressive, though. They're talking about the same thing in 922G. And admittedly, Your Honor, I haven't really briefed that because that's a separate, yeah. But I think 5861 is materially different because, and as this court has noticed in Nieves, we had the opposite problem, okay? In Nieves, they indicted as to this is a combination of parts, and then instructed the jury with the entirety of 5845, the entirety of the machine gun definition. They said, that's not permissible. I don't understand how they can accomplish the same harm in reverse.
You're arguing here that the indictment was insufficient, right?
So we've made several arguments. I do submit that the
But
indictment.
that's where you started, the
Yes.
indictment's insufficient. But didn't the indictment tell the defendant as to a couple charges that the firearm was a PPSH machine gun, that as to the destructive device, it was an M79 40 millimeter grenade launcher, and another destructive device, RPG recoilless anti-tank? Wasn't that in the indictment?
Anti-tank projector, yes, Your Honor. And if you see in our response brief, we map out these, the allegations in the indictment. Those words are not in the statute, okay? All of the other cases that the government points to have multiple words that specifically relate to a
All right,
specific definition.
Let's step back, because, I don't want to repeat
Right.
Judge Richardson, but are you saying that in order for the indictment to be sufficient, that the statute had to include M79 40 millimeter grenade launcher?
No, Your Honor, not at all. I think for the indictment to be sufficient, it would have had to clearly, without any uncertainty or ambiguity, identify the offense conduct, and that's not what it did here. It simply said
Well, it
machine
said he
gun.
possessed the grenade launcher. He
Yeah.
possessed the recoilless rifle, anti-tank projectile. What else are they supposed to have told him?
It said grenade launcher and anti-tank projector, and neither of those are in the definitions. So Mr. Adamiak is left to guess as to what that is. Respectfully, Your Honor, a grenade launcher is not in the statute, unlike incendiary bomb is a specific type of destructive device. One can know what they're defending against. And
I don't think I understand the argument. Can you tell me in that example, what was the language that you think should have been included? Like, what are the words that were missing?
Absolutely, Your Honor. In the case of an M79, or in the case of, as the government tried to, the government.
Let's just go with the M79. You
Yeah.
picked that one first, let's go with that one. What's
Right.
the M79? What are the literal words that they had to put in, that if they did not put in, you think the indictment is invalid?
Bore over half inch, not suitable or used for sporting purposes. As they did
So
in the
they
other.
can't, they can't use the word destructive device.
No, Your Honor, that's not what I'm saying at all.
So, but that is the definition of a destructive device.
It is a definition of a destructive device, Your Honor. It is a definition. And so there are many other destructive devices, for example, incendiary bomb, right? And then for the anti-tank projector, I'm not sure how to define that one
So
because,
they have to pick the definition, so they can't, so what they said here is the destructive device. They give you the specific one, and then your answer is that's not specific enough because they have to explain to you which of the three definitions is applicable to that M79
Your
in
Honor,
the indictment.
Your Honor, it's more like 10 or 12 definitions, but it's something in the indictment should put the defendant on notice as to the factual basis of the charge. That's not what happened here.
No. Well, you can't say the factual basis of the charge, right? Because
Yes.
that's Staples. In fact, Staples
Yes.
is pretty clear about what the factual basis has to be. You have to be aware of the facts about the M79, and by identifying the M79, there's no doubt about the factual basis.
Your Honor, I resist that strongly.
I
because
can tell you do it strongly.
The
The question is whether it's well,
I-
right? I
Your Honor.
totally get that.
grenade launcher is not a item under destructive device.
But destructive device is in the statute, right? You
Destruct-
agree the destructive device is in the statute, and it's in the indictment.
Destructive device as defined in 5845. So whether something is a destructive device or not is a legal question based on the factual elements in 5845, those different definitions. The jury is to find whether these facts were present in each particular item, whatever it is, okay? When they're divergent facts, we have no idea as to what, to put it this way, there'd be no possible way to test the sufficiency of the evidence here because we have no idea whether the jury, for example, all concluded that any particular thing was a incendiary bomb, whether any particular thing was suitable for sporting purposes.
What is the best case you'd have me look at to suggest that those different means are required to be found by the jury unanimously?
Well, Your Honor, we do cite in our main brief that something's status as a firearm under the National Firearms Act is a question of law purely. And so I'd go there and.
Well, you just were talking about, we don't know what the jury found. I just was answering, I was trying to give you a chance to give me a case to support the point that you just made, which was the jury, we don't know whether the jury found this, that, or the other. And what I'm asking you is, what is the best case you have, a la Richardson versus United States or Shad versus Arizona, that the jury must find the reason it satisfies the destructive device definition unanimously? The reason.
Your Honor, I don't have a case in front of me right now, but I can say that it is a clear defect when we have no idea how an individual was convicted with possessing a destructive device.
I totally get that, but that's just to disagree with the Supreme Court, right? That just says that Shad and Richardson versus United States are wrong, which you might be right, but that's just a really strong argument to make for us, it seems like to me.
Well, Your Honor, the other thing that's really instructive here is that none of these cases, aside from the one which we address in our reply, that specifically it was charged just as a destructive device, and this wasn't contested. Every other case, including the government cites Hoover, originally it charged just a machine gun. There was a motion to dismiss an indictment, exactly as there was here. The government came back with its machine gun, more specifically X, Y, and Z. It's not what they did here. And to be honest, it's necessarily deprives you of notice. You do not, Mr. Damiak did not have notice as to what he was being accused of. It is a materially different prosecution to have to focus on whether something was used for sporting purposes, whether it was a launcher, or whether it was a combination of parts. And we still don't know how they thought it was a destructive device. The government didn't even say so in their reply. They just.
In this case, there was a general verdict form, is that right?
Yes, Your Honor. And
Did you agree to the general verdict form?
Your Honor, I wasn't I wasn't the counsel there.
Whoever was at trial, did they agree to the general, did they object to it?
They objected and they had suggested more specific instructions.
I'm sorry, they objected to the general
No,
verdict form.
not the general verdict form.
So did they propose special verdict forms to take into account the things you're discussing?
Your Honor, that would have been, I don't believe so. But I still believe that the motion for judgment of acquittal and motion to dismiss the indictment should have been granted. Because at the end of the day, it shouldn't be too controversial to say that you have a problem when you send the jury out with the only question here is, I think I'm right to say that, and I have case law that we've cited in our main brief, that something's status as a machine gun or destructive device is a legal question. When you send the jury out to say the elements are legal question, that's what they said, that he had a X item, that it was a firearm under the act, and that he knew
But
that he
the
knew he had it.
factual question is like, does it factually meet one of the definitions, right? Like that is a factual question, right? Whether, as the example you keep giving, whether the bore is greater than a half-inch in diameter, right? Like, that's not a legal question, right? That requires like a dude with a ruler, right? Like, that's something the jury could find as a matter of fact.
But here's the other thing, Your Honor. All we know is that the jury was sent into the jury room with a pile of non-functional garbage. It's undisputed that none of the stuff worked as it was found.
Well,
And
they probably did not send them in with it, by
Yeah,
the way.
and-
They maintained them outside for good reasons.
And then was given the entirety of 5845 and basically said, figure it out. That is just not consistent with fair notice and due process. You have to know what you're defending against. Again, because let's talk about the M79, because that was a point we talked about. The government manufactured the M79. That's indisputed. The government put it together from stuff they found all over the place, right? That's a separate.
They probably
Thompson Center-
originally manufactured it too, right? In an M79, a military grenade launcher?
Well, wait, who had manufactured, you're saying?
Didn't the U.S. government, in an M79, a U.S. military grenade launcher?
It is such a categorization, but no, what I'm saying is that the government assembled it from parts it had found. That's indisputed. So how do we know? Was he being accused of a combination of parts, or was he being accused of having a non-sporting firearm above a 40 millimeter, or above a half-inch bore? We don't know, because they refused to articulate the theory of criminality. There was no way to adequately defend against this when the government refuses to articulate this theory in a divergent statute. And so I guess the real question is, if we're going to insist on allowing the government to indict on the entirety of 5849, it's necessarily vague. Necessarily vague. The only way it's saved is when we say, just like all of the other cases, Your Honor, I've run out of time, may I complete my response?
Yeah, very briefly.
Just like all the other cases, this was a X because of Y. That's it.
All right, thank you very much. You've got some rebuttal time. Ms. Becerra?
Good morning, and may it please the court. Jacqueline Bashara for the United States. I can start with talking about the sufficiency of the indictment. Judge Richardson, you are correct that the element that was required to be specified in the indictment here is a firearm. We know that from the statute that's charged. If we just look at 5861D, it prohibits any person from receiving or possessing a firearm, which is not registered to him in the NFRTR. So then it cross-references 26 USC 5845. That's a definitional section, and it starts at the top by saying a firearm includes, as relevant here, a machine gun and a destructive device. And then it goes on to provide various definitions of machine guns and destructive devices. Those are all means of satisfying the overall element of a firearm. And here, each count of the indictment.
Is your view that you could do that? Not that you do it, but that you could do that you could actually just charge firearm in violation of Title 26 without specifying machine gun, destructive device, short-barreled rifle? I think the answer is yes, under your view. You probably would then have to respond to a bill of particulars,
Yeah.
but I take your position to be that, like, you actually could have done even less than you did here?
Probably, because our position is that's the element, but I agree with you. I think that would wind up in a bill of particulars. That would have been the appropriate relief, I think, to get at what the defendant, his concern is here. Really, a bill of particulars would have provided perhaps more facts, although I think Judge Azzi is correct that this indictment actually provides all of the necessary facts to defend against these claims because it specifies the date of each possession or receipt, and then that it was knowing, the specific firearm that is at issue, the specific, I guess, sub-definition of firearm, either a machine gun or a destructive device that it is alleged to constitute. And then, of course, it charges the statutory code sections, which we know in all of the Rule 7 cases, that's basically enough. I think that a bill of particulars would have been the way to get at the sort of factual concerns that my friend has highlighted. However, the defendant never moved for a bill of particulars. But I would push back on the suggestion that the government's evidence at trial was a total surprise. I don't think that's founded. Particularly, we have certain discovery obligations, and of course, well in advance of trial, we had to produce the expert reports. Just as one example, if you look at the one pertaining to the PPSH 41 is at JA 2454, and the one pertaining to the destructive devices is at JA 2465. And in both instances, each expert set forth the applicable statutory definitions and then provided a detailed explanation of basically a visual examination of each firearm, a physical inspection, and then set forth at least one government witness's assessment of how that charged firearm would satisfy the statutory definition. So I would submit that
Can I
that
ask
at
this
minimum.
question? I might not be looking in the right place. I see destructive device, and there are 3 different types. Your colleague suggested there were 8 or 9, but the 3 that I see listed here in the actual statute, was the jury instructed on all 3 of them? So in other words, when the jury got the instruction about the M79, was it instructed that it could find that to be a destructive device if it was poison gas? Which is one of the things this is a destructive device? Do you understand what I'm asking?
I understand your question.
Do you,
If you would mind if I can
no,
just
no,
pull it up,
the answer is I
can't
don't remember is totally fine.
exactly.
Because it might, I'm not sure
So
that it's
there was
relevant.
one overall instruction setting forth the definition of destructive device. It wasn't specific to, okay, now we're moving to the M79. I just want to pull them up just so I'm absolutely sure.
Is there,
Okay, and so I'm at JA 817 now. So it starts with, yes, so they were instructed. They were instructed on basically the entire
Statutory language.
5845F pertaining to destructive device, and that was, of course, with the defendant's consent. He didn't object to that. Also, to your point, Judge Agee, earlier, he didn't object to providing the jury a general verdict form rather than a special verdict form, which would have, I guess, provided unanimity that he now says was required. Of course, we don't agree with that because the means of satisfying the firearm requirement the jury doesn't have to be unanimous as to that. I guess I can touch briefly on the notice issue. The district court was correct in determining that the indictment provided sufficient notice. It's not unconstitutionally vague as applies to the defendant. And Judge Richardson, I think you were correct to point out that Staples kind of solves this problem. That's what the Supreme Court said it was doing by reading in the mens rea requirement as to basically having knowledge of the characteristics that bring the firearm within the scope of regulation by the statute. That it serves to ensure that we're not criminalizing potentially innocent conduct.
Can I just run through 2 things just to make sure I understand the government's view on them? One, on the Second Amendment, do you agree that Bianchi sort of controls here?
Yes.
And that's sort of the end of that story?
I think so.
And then on the double jeopardy claim, do you agree that there's a problem and that the problem is because both include possession?
Yes.
Is that the
And
right way of thinking
We
about
have
it?
conceded that
Yeah,
in
no,
our
no,
brief.
I'm just making sure I understand. In theory, you could have charged both of them as long as you didn't include possession in both of them. But once you include possession, we've now got an overlap, and that's the problem. You could, in theory, charge both statutes.
Right.
One's receipt, one's transfer, but once you put possession in both, I'm not trying to be critical, I'm just trying to make sure I understand the
I hear
government's
you.
position. That's what makes them a problem under Blockburger.
Yes.
And so we would end up sending, I was a little confused by your position there.
Okay.
Are we, usually there's a recommendation that we vacate one and then send it back for resentencing, but you haven't specified which one. Am I correct?
That's correct. I guess I didn't see a requirement in previous cases
Well,
where
I
that's
mean,
been the
I don't know if
request
it's a
to.
requirement, it's just my.
The statutory maximum on both counts is the same, so I guess we could work that out in the district court. Of course, our position
theory,
is
we
that there
could-
should be no resentencing.
We
But-
could vacate the sentence and remand with instructions to dismiss one of the duplicative charges.
You could.
Now, maybe I've got this confused with another case, because this is the end of the week, but I thought there were 220-month sentences assessed, and they were consecutive.
Yes.
So that would seem to require a resentencing in and of itself, wouldn't it?
I'm not sure. Maybe the court could just correct the judgment, but I could double check if the
We
court has.
generally say, I mean, actually don't know that, but in lots of areas, we say sort of sentencing package doctrine means like, once we vacate one sentence, at least where that sentence affects the total, it seems like we gotta send it back and let the court reevaluate. Because in theory, based on the other convictions, it could reach the same number if it was so
And
inclined.
I think it will.
Well, we can read the transcript, but that's up for the
That'll be
district
up
court
to
to
them.
determine.
So you've certainly got time if you wish to talk about anything else, but we've read your briefs, and that would be up to you.
Unless the court has further questions.
All right, thank you
We
very much.
ask that you affirm.
All right. Mr. Larseri, you've got a little rebuttal time.
Thank you, Your Honor. May it please the court. My friend on the other side points to Staples, points to some other cases, just conclusively states that they're instructive here. I don't know how they are. Staples, what characteristics? When we don't know what the particulars are, how can we know that he had knowledge of any particular features?
Yeah, well, not to beat a dead horse, but it seems like in that circumstance, you just asked for the bill of particulars.
So, even so, there's still the major question here that these are not, and we can't just point to Yankee, right? These are not normal weapons. These don't work. So we don't get to simply assert dangerous and unusual and avoid a Second Amendment analysis, right? This isn't a facial attack. The Second Amendment question, which we only have to reach after saying that, okay, no, there was fair notice that, however the court might reach that, there wasn't any problem with the jury instruction, there wasn't any problem with, that a reasonable jury properly instructed could have reached this, okay? We now have to assess whether or not the government actually carried its burden under the Second Amendment. The simple Second Amendment allegation was, whatever this is, we're not saying machine guns broadly, destructive devices broadly, whatever this is, must then be a accoutrement qualifying as an arm, and including especially the PPSH, which was just a bunch of parts, so necessarily a trigger or a buttstock is a protected part. The government then has the obligation to show some kind of history and tradition of regulating whatever it is out of existence. That has to turn on the facts of this case. And it's undisputed that they don't
Is your
work.
argument here that as part of the government's case in chief, in a case that involved firearms, they have to make a separate presentation in their case in chief to show that the Second Amendment is not violated?
Your Honor, that's what Bruin says. Whenever someone articulates a restriction on the right to keep and bear arms, which was articulated below.
Right,
The
that's a
government,
little different. I mean, certainly if the defendant raises a Second Amendment objection, the government will have to do that, but I'm not aware of the cases where the government's case in chief has to specifically address a Second Amendment claim that's never raised.
Your Honor, the Second Amendment claim was raised
Okay.
in the motion to dismiss the indictment, and the government refused to address it. That's the problem that's articulated. And we only reached that so far down is because we felt that there were so many other off-ramps for the court to take. But if that's where we're heading, it becomes a critical problem that the government never addressed the Second Amendment claim. That was brought down below.
Can you help me, I don't understand how you, like, work that under Bianchi. So we have to apply the Bianchi framework. And so I understand the argument that you're making, but Bianchi seems to say we don't have to do that when we have, the type of weapons that Bianchi describes, and certainly this seems to fall in that bucket.
Your Honor, Bianchi was talking about weapons, actual weapons that worked, that could cast harm against another.
So that, your argument is like, once you sort of partially disassemble these to try to get around the regulations, then, that actually that's your, okay, I didn't understand that to be your argument. Your argument is like, if we pretend to take these apart, then in that world, they can no longer be regulated.
Well, hold on, Your Honor, you're saying pretend. These are not taken apart. They are cut up. It's undisputed that the anti-tank projector, if somebody tried to fire a rocket through it, would, as the government's expert stated, remove the user's head. That's not a weapon. So whatever it is, again, it is parts or whatever. Second Amendment protected accoutrement. You need to show history and tradition of regulating those to the point of locking a man in prison for 20 years for simply possessing them. They didn't even try. They just said, we don't have to, and pointed to pre-Bruin case law. That's just not how it works. You have to address it with the arms that are before the court. And what's before the court right now is a pile of cut-up, non-working, historical memorabilia that couldn't hurt anyone, and that's undisputed. I see I've run out of time. Thank you so much for your time, Your Honors.
All right, we appreciate the argument from both counsel. I'm going to ask the clerk to adjourn court, sine die, and we'll come down and greet counsel.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.